chairpersons of SADC PF standing committees, representatives from anti-corruption agencies, human rights commissions, investigating units of police. We also had others from the prosecution and civil society, where we were pre-testing the tool. And we got very vital feedback from the process. And the rapporteur for that session was Mr. Landlani Banda. And we are privileged to have him rapporteuring this session as well. He also happens to be the one who developed the tool on human rights. So he will be able to provide that interface in terms of feedback from what came from the parliamentarians and the other stakeholders, so that as we move forward, we are able to integrate the feedback. Maybe to start off, let's have introductions so that we know who is in the room. And after that, we'll do our official opening session, and then we will proceed into the document. Hilda, may I honor you by requesting that you be the first one to shoot.
Thank you, Kurasha. Good morning, everyone. Hilda is my name. I am from the Electoral Commissions Forum of SADC countries based in Gaborone, Botswana. Thank you.
Sophia Shale, member of the TWG, but also working for Development for Peace Education in Lesotho.
My name is Wonesai working to Sitole. I'm the regional police and liaison for the International Organization for Migration and member of this technical working group.
Good morning. My name is Joseph Dume. I'm from South Africa. I work for an organization called Disarmament in Arms Control.
Graham Matenga, I'm with International IDEA based in Nairobi, Kenya.
Good morning, I am Ishara Bodasing. I am part of the TWG. I run a governance consultancy.
Good morning, my name is Buseso Marapedi. I work for the Platform to Protect Whistleblowers in Africa. I'm also a member of the Southern Africa Anti-Corruption Network.
Morning, my name is Dipiana Msopole from the SADC Secretariat. I'm a member of this technical working group.
Morning, colleagues. My name is Sukani Ngube. I'm with the University of Johannesburg, where I head the Practical Business Law Department and researchman in public law. And I'm a member of the technical working group as well. Thank you.
Thank you very much. It would be good to have colleagues from the Secretariat introducing yourselves, apart from the Secretary General, so that colleagues also know who's in the room.
Thank you, Shoneni. Good morning, everyone. My name is Yapoka Yurenda Mungandi. I'm Director of Finance and Corporate Services at SADC PF.
Good morning, everyone. My name is Paulina Kangwashivi. I'm the Assistant Procedural Officer and Coordinator at the SADC PF. Thank you.
Good morning. My name is Pedro Lusakalalo. I'm the Portuguese translator at the Secretariat of the SADC Parliamentary Forum.
Good morning. My name is Agnes Lilungwe. I'm the Executive Secretary to the Secretary General, SADC Parliamentary Forum. Thank you.
Good morning, everybody. My name is Vach Kublal. I am the project accountant of SOH project, and I'm the secretary based in Mauritius. Thank you.
Good morning. My name is Ronald Venver. I'm the ICT officer for the SADC Parliamentary Forum.
Good morning. My name is Mino and I'm an ICT intern at the SADC PF.
Good morning, everyone. My name is Michel Gondo. I'm from the SADC Youth Forum. Thank you.
Landy, you want to introduce yourself?
Good morning, everyone, and welcome. My name is Landilani Banda. I'm from Zambia, but I'm also based here in Pretoria. I am the consultant that developed the principles and guidelines for parliaments in the protection and promotion of human rights. And I'm also a member of the technical working group. Thank you.
Thank you very much, colleagues. I'm sure we now have an idea of who is who in the room. We have a few other colleagues that will be joining. Others arrived early this morning, and they will be joining during the course of the day. So as we communicated through the program, we thought of convening this meeting to benefit from your input as we seek to finalize the knowledge tools we have developed, the one on curbing corruption and the other one on protection of human rights, all centering on the role of parliament. And as indicated in the program, we precisely would want to benefit from your input in order to ensure that the knowledge tools comply with international standards and best practices, to ensure that the tools are efficacious to meet their policy objectives, and ensure alignment of the content with the stakeholders' needs and expectations. And then we also wish to benefit in terms of even review of form in addition to content, proposals on how we can package the tools themselves or any other sub-products that might come out of the tools for purpose of effective communication with parliamentarians, with citizens, and also other stakeholders. So to get us to officially start, I wish to invite Madam Secretary General, Madam Boemo Sekoma, to deliver a welcome address and open the meeting. Over to you, ma'am.
Good morning, colleagues. I'm sure there's no bonjour or bon dia this morning. Thank you for making it, and welcome to this important meeting. As you've all heard, it's a validation meeting. And on my part, it's really with humility that I appear before you as experts in fields of democracy, human rights, and development. As I deliver these welcome remarks, I must indicate that your efforts throughout the process of the development of these tools have been visible, and I've been seeing how various organizations in this regard have taken this collaboration quite seriously. And on the side of the forum and on my own behalf, I'd like to express our appreciation. As you're well aware, and as indicated by the Director of Ceremonies, we assembled today under the aegis of the Technical Working Group of the Democracy, Governance and Human Rights Standing Committee of the SADC Parliamentary Forum to perform a head surgery as a way to validate crucial knowledge tools that can be a game changer for the future of parliamentary initiatives in the SADC region. Colleagues, these knowledge tools, notably the principles and guidelines for parliaments to curb corruption and to promote human rights, have been successfully pre-tested with multi-stakeholders during the last 2 days. And you'll benefit from the enhanced and distilled version of these knowledge tools, which will be submitted for validation by the technical working group. Undoubtedly, the knowledge tools are expected to bring further momentum to the SADC Parliamentary Forum's initiatives to promote democratic accountability and assist the forum in becoming a regional powerhouse to foster leadership in normative standards. The next steps after this meeting will be a recommendation to be made by the Democracy, Governance and Human Rights Committee when it considers these tools as part of an agenda item in their next meeting. They will then refer these tools to a joint session of standing committees of the forum, and thereafter the approval to the plenary assembly session in July, Arusha, Tanzania, which is the main policy-making body of the SADC Parliamentary Forum. In other words, pursuant to this validation meeting and the usual adoption process, the principles and guidelines will be embedded into the forum's body of regional parliamentary policy and will buttress the forum's existing Bill of Rights. That is, it will join the model laws and other developed minimum standards that the forum has adopted. Dear colleagues, I would like to say a few words about the rationale behind the development of these knowledge tools to assist us as we validate and make further input into the tools. As you may be aware, the mandate of the Democracy, Governance and Human Rights Standing Committee itself gives a strong foothold for the existence of such tools, since both the anti-corruption framework and the promotion of human rights fall within the ambit of the portfolio of this particular committee. In addition, allow me to congratulate you, Mr. Sheunene Gurasha, for your sterling work in coordinating the work of the DGHR Technical Working Group and the committee, and implementing such interventions with zeal in this regard. I'd like to mention that as a technical working group, by adopting these principles and guidelines, the DGHR committee is in fact exhausting its work plan in accordance with the 5-year strategic plan of the forum, which is to end by the 31st of December, 2023. Indeed, according to the strategic plan, 2019 to 2023, the forum through its standing committee is to promote human rights and contribute to the consolidation of the democratic drive by mitigating corruption and heightening transparency and accountability. Colleagues, we are thus well within the domain of the committee work in accordance with the committee's statutory mandate under the forum's constitution and the rules of procedure. Through the DGHR committee and its technical working group, we are pushing closer to our long-term goals and targets, and I wish to congratulate you for such efforts. Undoubtedly, this validation meeting, which will take place today and tomorrow, will propel the forum several steps nearer to the attainment of its objectives, as I've indicated. It is also important to mention that the principles and guidelines will also concretely support provisions in the developed model laws, especially the preambles, which deal with human rights approach to statutory interpretation. You will note that one fundamental principle in the human rights knowledge tools is that of universality, which means that human rights are universal and apply to all individuals without discrimination. While all model laws developed by the forum so far depend, of course, on the notion of universality, it is indeed now through these principles and guidelines that such detail can be considered and embodied into the forum's body of parliamentary policy. Looking forward, the principles and guidelines will thus become supportive and complementary to the interpretation of statutory provisions contained in the model laws that the forum has developed and other guiding legislative benchmarks developed under the umbrella of the plenary assembly and the forum. Colleagues, these guidelines and principles should thus not be viewed as separate documents, but rather as overarching documents which are linked and give credence to already existing normative legal standards. We must think of the protocols that we have at the regional level. We must look at continental frameworks, Agenda 2063, the African Charter, among others, because this will be quite important in terms of us locating the forum and being relevant to what our executive and members of parliament have already ratified. Colleagues, I'll now turn briefly to the lessons learned during the pre-testing phase, which have informed the validation meeting of today. Let me point out that lessons learned from the pre-testing phase included the need to rationalize with domestic human rights provisions, to appreciate the clear demarcation between parliament and the executive within the realm of the doctrine of separation of powers, and to further appreciate that socio-economic human rights are as important as civil and political rights, even if they are not usually part of some national constitutions or Bill of Rights. In addition, there were recommendations made along the lines of streamlining the principles and guidelines with some of the key instruments like the Sustainable Development Goals, especially SDG 3 on health and well-being, SDG 5 on gender equality, as these are national commitments taken by most SADC member states and are intertwined with both anti-corruption framework and the advancements of human rights. These comments, along with many others, have been duly taken into account, and you will get the feedback from the rapporteur of the session. And more will be told about the possible adjustments made by the presenters today and that were made to the pre-testing session. Allow me at this point to also say, as we get the feedback, it is important not to usurp the powers of Parliament's independence and ability to implement effectively their mandated roles. It is also important to not vie off existing instruments and language in terms of ensuring that parliaments are also not left out of what are the principles of what assist them in terms of doing their work. As I have indicated, we have indeed taken note of the comments that were made, and it is for you as the technical working group to make the necessary adjustment to these tools so that we can progressively move forward in that direction. Moreover, I would like to highlight that these principles and guidelines are also not cast in stone, since they do not allude to any specific anti-corruption or human rights provisions. In fact, they are to a large extent aiding to the interpretation and application of substantive provisions that may exist or will be in existence at national level. So as we go through them, as we make our input, let us not be limited by what we know today. Let us also be encouraged where we need to go with this principle of enriching parliaments and improving the lives of our people. The principle, of course, should provide for a robust foundation on which parliaments may act upon to implement specific human rights or make customized improvements to the national anti-corruption framework or the human rights framework. They must constitute the means to achieve an end more than being the end itself. They must provide context and a doctrinal knowledge necessary for linear progress to be made in enhancing the anti-corruption framework and implementing a culture of human rights. Accordingly, the principles and guidelines are not answers in themselves. However, they pave the route for national parliaments to promptly find the answers that they are looking for in their quest to resolve corruption and allow citizens to hang their hopes on human rights predicaments. Before I conclude, I'd like to highlight that the knowledge tools are also accommodative of the fact that different countries are at different developmental levels, and therefore the tools are to be adapted at national level before being internalized. We recommend that going forward from the validation, the domestication and internalization process takes place through a multi-stakeholder platform such as through yourselves as a national working group, or you could further look at national working groups at country level in view of identifying bottlenecks and pitfalls that make it insurmountable or surmounted into the process. To ensure a comprehensive acceptance of the knowledge, it will be important for you as partners to, through your planned activities, to take these and pre-test them further to allow us to be real and much more ready for the domestication process, because acceptance and knowledge of these tools will go a long way in terms of them being inclusive as possible in ensuring that civil society organizations, NGOs, and other traditional faith leaders and other statutory bodies, such as human rights commissions, have contributed actively to access this particular tool, and therefore avenues for us to look into in terms of domestication. We are confident that the validation phase of today will further assist to refine the knowledge tools until they are adopted. We are kindly expecting an open and frank interaction to ensure that the validation version of these knowledge tools adequately reflect both the lessons learned and pre-testing stage, as well as the views of yourselves as technical working group. I'll also wish to kindly thank your organizations for ensuring that they share the time. This is contribution in kind to the work of the forum, and for yourselves for demonstrating that relentless support that can indeed bring the forum to the heights of parliamentary excellence. I thank you for your kind listening and commitment and dedication through your assiduous efforts for consistently monitoring and supervising the development process. The drafters of these instruments, I want to thank you for sharing your knowledge and wisdom along these journeys, and I wish you fruitful deliberations.
Thank you very much, Madam ASG. We acknowledge the recognition we appreciate, and we owe it to the team. And we also want to echo the sentiments of the Secretary General regarding the critical role that colleagues are going to play, and also the generous gesture from your respective organizations to collaborate with us. The remarks set the tone in terms of how we are proceeding the next 2 days. Before we proceed to comments, I recognize colleagues that joined after we have started. We wish to give you the opportunity to introduce yourselves, and then we'll be able to proceed. Morini, I give you the floor.
Thank you. I'm Maureen Shonge. I'm joining you from the UN Women Regional Office in Nairobi, responsible for governance and political participation. Thank you so much.
Thank you very much. I saw your email this morning, and I saw that you came during an hour, which in Shona, we reserve that hour for owls and witches. We're sorry with what happened, but we are happy that eventually it was resolved. Unaro.
Good morning, sir. My name is Unaro Mungenje from the SADC PF Secretariat, tasked with logistics and protocol services. Thank you.
Thank you very much. So how we proceed, I mean, we proceed. Because we're looking at content and form, we propose that we actually go into the actual document rather than a PowerPoint presentation. And when we consider a section, we will, the rapporteur will start off by sharing the feedback or the major feedback that came from the pre-testing meeting. And then we receive any further inputs and guidance from the technical working group before we validate that section. That is the proposal on the table. Any counter proposal? So is the proposal seconded? Those
Yes.
who agree will say aye. Thank you very much. I think we can proceed that way. Landy, do you need any facilitation to be able to do that, or you'll be fine?
I think I'll be fine.
Okay.
I'll be able to capture the feedback from the room.
Sure.
And I think I can write them down.
Okay.
Thank you very much.
All right. So we decided when you look at your program, it indicates that we're going to start with the tool on curbing corruption. We have had to make a slight adjustment. A consultant for that tool has just assumed a new role and is having time limitations. And so we have agreed that he will avail himself tomorrow morning, because what we needed to do is to have conversations with him internally following the feedback that came from the pre-testing process, so that when he engages with the technical working group, he's appraised in terms of both processes, and the engagement will be much more meaningful. With that, may I hand over to you, Landy, to take us through the process, and all the best, colleagues. Thank you very much.
Good morning once again, ladies and gentlemen. So as Klasha said, today we'll start with the validation process of the principles and guidelines for parliaments in the promotion and protection of human rights in the SADC region. I think I should start by saying that during the pre-testing session, what we did was prepare a PowerPoint presentation, and we focused on the actual principles and the guidelines. There were certain aspects of the document that we didn't look at, which were more or less formality, some of them background, and some of them conclusion. But I think for purposes of the validation, we can start with, we can look at the whole document and give our thoughts, give our concerns, if any, so that we can properly say that the document has been validated. And the starting point is always the starting point, the cover page and the title. The title is the Principles and Guidelines for Parliaments in the Promotion and Protection of Human Rights in the SADC region. So I think that it's an appropriate title that captures the essence of what the document seeks to talk about. I think that it captures the fact that there are two components to the documents: one, principles, and number two, guidelines. So The document starts with the usual table of contents. It's a list of acronyms, acknowledgements, and I think that I can skip this and go straight to the list. The list of acronyms is there. Because we are trying to really concretize the document and make sure that it's as perfect as it can be. If there is an acronym that we have left out, you're more than welcome to just be able to point it out. Sometimes when you read a document too many times, it becomes too familiar and you're not able to see. I see a hand, yes, sir.
Yeah, I just want to check in terms of the title of the document itself. That you made reference to Parliament. Are you then saying that it's only within the collective that is Parliament, or individually as parliamentarians to be responsible in promoting these guidelines and principles? Because I was thinking that maybe it could say Parliament and parliamentarians, so that individually as a parliamentarian in their own constituency, they can also try to promote and encourage the protection of human rights.
Before I come in, are there any other comments with respect to the title? The idea was, in terms of the content, you will note that it contains parliaments and parliamentarians in many aspects, but we thought for purposes of brevity in the title, parliaments subsumes parliamentarians to a large extent. So we didn't want to be, as others would say, tautological. So we just try to use parliament, and I think it still does capture the essence that parliamentarians are captured. I don't know if that is sufficient.
That's fine, it's okay.
Thank you very much. So we were at the list of acronyms. Unfortunately, because it's a validation, for me, it's important to go through every page as the case may be. So if there is any acronym that hasn't been captured, I think that's a small issue to raise at any given point. And so we can move on from this point. And we have acknowledgements. I think this is more for the Secretariat, and I think we can get feedback on this in the event that we need to recast the acknowledgement, but we tried as much as possible to capture everyone who played a role in the development of the principles and guidelines. And if anyone has been left out, of if something has to be recast on the acknowledgement page, I think it's more than welcome. Yesterday, like I stated, we didn't look at the acknowledgements, but there is an opportunity to comment on the acknowledgement.
Just a minor one on in terms of funding, which is also Austrian. Sorry, just in terms of the funding, it is the Sweden government and the Austrian development agents through GIZ.
Yeah, that is very well noted. Thank you. Any other? So then we have a forward that was done by Secretariat. And I think that when I read it, it's really appropriate and speaks to the content of the document. But again, as we are trying to enrich the document, are there any thoughts on how the forward can be developed, concretized? Yeah, we were just liaising about whether a forward can really be subject to amendment, but in case there's a typo and any grammatical or concern in terms of part of the content, its accuracy, I think it's more than welcome. But I see no one, so we can move on to the preamble. Yesterday, we didn't look at the preamble, but I think that in a document of this nature, a preamble is very, very important. Before I get into the specific aspects of the preamble, what we were seeking to do with the preamble was to really carry the spirit or give the spirit and background of the document and capture the spirit, capture the essence and hopefully the expected outcomes of what we hope the document seeks to achieve. So we included a preamble in the document, which I can either go through or I can allow members to simply read. I don't know what is the feeling of the House.
I was just going to make a minor comment in terms of our style. Whenever we see parliamentarians, we capitalize them. And whenever we see parliaments, we capitalize them.
I think I'll try to read the preamble. It's recalling its mandate to provide a platform for parliaments and parliamentarians to promote and improve regional integration in the SADC region through parliamentary involvement. Recalling further its objective number 1, to promote human rights, gender equality, good governance, democracy, and transparency. Bearing in mind Article 9, Sub-Article 2 of the SADC Treaty, which sets up the SADC-PF as an autonomous body presenting parliaments and parliamentarians in the SADC region with the mandate to, inter alia, strengthen the implementation capacity of SADC by involving parliamentarians in the affairs of SADC. Noting the critical role that parliaments play to ensure the respect, protection, and fulfillment of human rights and fundamental freedoms of citizens. Noting further the special position that parliaments and parliamentarians play in ensuring the respect, protection, and fulfillment of human rights. Concerned with the state of human rights within the SADC region. Concerned with the shrinking democratic and civic space within the region and the challenges faced by human rights defenders, particularly women human rights defenders within the region, aware of the need to provide guidance to parliaments and parliamentarians within the SADC region on principles for the promotion of human rights. SADC-PF solemnly declares that these principles and guidelines for parliaments in the promotion and protection of human rights in the SADC region. So that is the preamble. Are there any areas which require addition? I see two hands. I'll start with Graham.
Thanks, Landy. My suggestion is that maybe we should make an additional sentence to the, that recognize the existence of these global and the continental frameworks guiding human rights. And I think that should be probably at the very top, or yeah. Because I think in its current form, this is all about SADC. But to what extent does this embed into the global and the continental frameworks?
If I can supplement on the same before we move to the next, maybe in the same vein, even the reference to SADC is not with regards to the human rights framework, SADC. So if we can then, in terms of how we do it, that hierarchy in terms of subsidiarity, where we recognize SADC continental and the international.
I saw another hand. Yes, sir.
I think there's bearing in mind, I think, is it supposed to be representing or presenting parliaments? The other concern that I had was on especially the second concern with shrinking democratic and civic space within the region. Again, I think I'm just thinking aloud as to where was the evidence, because at the same time, there are also efforts within the region to advance in order to ensure issues of gender equality. And I can even cite, I think, even the adoption recently of the SADC mechanism for engagement with non-state actors. In other forums, it might be seen as if we are concerned about a problem where there is also progress. Maybe if it can be concerned, I don't know how it can be crafted in such a way that we're not trying to portray as if things are terrible, they are going backwards, when in other forums there are efforts that are being made to ensure that they move forward.
I think how it can be recast then is to speak in the positive, but aware that efforts are being made to address the shrinking democratic space or civic space. I don't know whether that would be better.
Sorry, I actually had a different view, because I think that's actually a specific concern, if I can just be broad, because if we look at the region, we do have shrinking democratic and civic space as a challenge. We have issues around constitutionalism and human rights adherence as a challenge. So I think the fact that you say concerned means that it's an issue of concern. We're just highlighting, and it's not meant, I suppose, as a criticism, but to just highlight that this is a challenging issue. And then my other point was just on noting further the special position that parliaments, I think you need to say fulfillment of human rights in that sentence, just a typo.
Is this a concern of SADC Parliament, or it's a concern of the technical working group, or is it a concern of the parliamentarian that we are implying here?
The implication is that it is a concern of the SADC PF because it is a document of the SADC PF, but it comes from the recognition that there is indeed a shrinking democratic space. But I think one of the, if you permit me, maybe one way to address the two contributions or the two concerns is to leave it there, and then to have another one aware of the efforts being made to address the shrinking democratic and civic space.
Yeah, maybe what is needed is if SADC Parliament did a study that substantiates the statement, especially this one and the one on the state of human rights in the SADC region. If you have got studies that you use as a basis, then that's okay. But if there are no studies that the SADC Parliament did to substantiate these two statements, you might actually have problems and say, what is your basis?
Okay, thank you. My observation is where we mentioned women, human rights defenders. I don't know whether it's deliberate to bring up women or we want to be inclusive and maybe make reference to marginalized groups. I don't know. Maybe it was deliberate to specifically mention women, but perhaps if you want to be inclusive, then we can make reference to marginalized and just leave it as open as that. Thank you.
Thank you very much. Very well noted. I think it would be best to be inclusive, although there was a specific cry that the document should specifically contain that particular paragraph in the preamble. But I think to be more inclusive, we can broaden it, but still leave the semantic of women human rights defenders. Otherwise, we'll be in trouble, so to speak. With respect to, oh, I saw another.
Thank you very much. I'm sorry that I'm taking a floor again without giving other people a chance. I was actually thinking that maybe the concerns that you start with, concerns with the state of human rights within the SADC region, if you could remove democratic from the shrinking, leave it with, shrinking, with the shrinking of civil space, and then continue with that sentence, and then democratic, move it to concerns with this state of democratic processes and human rights within the SADC region. Because I think we don't have a collective understanding of what we mean by democratic, interpretation, unless if the SADC has a collective understanding of what we mean by that. Whereas I think we do understand that the space for civil society or civil space is shrinking because a lot of whatever is happening currently in the region is because the space is not there for civil society to participate freely. So therefore, I think the word democratic, if it can be moved to the first consent, then it, I think, addresses the whole issue of what does it mean when you say democratic space is shrinking, because we don't clearly, there's no collective understanding or definition of democratic I don't know if I might be wrong, it might be there that what do we mean by democratic in the SADC space, so yeah, thank you.
I think it would be incumbent to get the feeling of the House on this proposal. What do others feel? We remove democratic and we put it on concerned with the state of democratic processes and human rights within the SADC region. That is the proposal. And then we have concerned with the shrinking civic space within the region and the challenges faced by human rights defenders, particularly women human rights defenders. Yes, sir.
Thank you very much. I don't think we can remove it there. And if we want to qualify any other provision, then we can do that without necessarily removing it here, because democratic and civic space has got its own significant meaning here. And secondly, I want to go back to when Dade Tole was saying, do we have studies to that effect? And I was not sure whether his concern is caused by the fact that we are saying we are concerned. I don't know if we used another word, you will still have the similar challenge, because for me, I think I get what he's saying, but at the same time, I don't think we can be realistic to run away from the reality that we know. So I am not sure whether if we can remove the word consent, put something like recognition or another word, will he still have the same concern now? Thank you.
My assertion is that you can only use the word concern when there's evidence. And when you don't have the evidence somewhere as SADC-PF, you cannot have a concern about it. This is where I'm taking it. So if there is a report that substantiates this concern to the SADC Parliament, then it's fine. Because the people who are going to go through it will ask for evidence, and we should be able to say our evidence is emanating from this. But when we don't have that evidence, I don't think it's prudent for us to put it there as a word concern, unless we provide substantial evidence to provide that.
Unless we get something else.
Yeah.
I saw a hand that I think wanted to address the same issue. You might go ahead.
No, I was just making reference to how the protocol against corruption cited these concerns, because I think corruption is also a sensitive issue. Instead of referring to the region, they just said concerned about the adverse and destabilizing effects of corruption throughout the world on culture, economic. So I think they are trying to run away from the region, and but to still express the concern that the corruption has destabilizing effects.
Go ahead, sir.
Yes, thank you very much. In addition to the previous speaker, I just also want to make a reference that the region, coming back to the research, there are also some gatherings, communique and documents that have been done by the region. Take, for example, the case of Eswatini. SADC itself released a statement, so that can be a reference point. If you look at the case in Mozambique, there is a communique, it's a reference point. And within those references, you find that they were concerned also with regard to some of the aspects. So we can use collectively, then maybe coming back to him in terms of generalization to say we are not in particular juncture pointing to a particular circumstance, but bringing it as a concern, which means there's an action that needs to be taken, and making reference to that. Thank you very much.
There was another hand. I think I saw the lady there.
No, I think it's okay. He's covered it. I was just worried about the high threshold of us wanting to find reports that support that statement. But I think he's highlighted where that can be found. Thanks.
I wanted to remind the House that the gender-based violence, which is rampant across the region, it's a human rights issue. Probably we are thinking too hard. And so it's good that we have found middle ground in the way we have, and we can be able to generalize. Where I was also going to highlight Landi, and the House can respond. There is no acknowledgement in the preamble. So in terms of balancing current efforts with where the gaps are, probably where we can acknowledge the efforts that have been done, the areas such as the one that I cited of GBV, while the cases continue to be rife, it is clear that a lot of effort has gone in, both on the part of SADC Parliamentary Forum, and other actors. Thanks very much.
Representing. So I think that the various views have been noted, and I've taken down the note, and I will be able to.
Sorry, Land. There is the concern or the observation made was the rights extend beyond citizens, even people who do not who are stateless also deserve rights, even those that may not be citizens, who fall outside the category of citizens. I don't know how you will craftily capture that concern, that observation. I don't think it was a concern.
Would that suffice?
Where we say of every person.
Yeah, I think it's fine. I would have you could have even just ended on freedoms, the critical role that parliaments play to ensure the respect, protection, and fulfillment of human rights and fundamental freedoms. But if we say of every person, if you like to expand on that, then that's fine. You could also end there. The assumption is that it's of persons, right?
If I had to make a choice on it, I would omit and end at freedom. There was a just comment by former president, the late Robert Mugabe. So people were saying human rights, and no, it has kept me. I'll share during tea. The joke was about people-driven constitution, and then he said, but is there an animal-driven one?
Yes. Indeed. I have a question also on the preamble.
Okay.
There have been a lot of questions that has been raised by Parliament about external influence into their democratic processes. And when you look at these principles, I don't see us actually taking these principles, actually trying to address some of those issues that most of the government in the SADC has been raising. So will they see us as a fair body when we present it like we are talking mostly from our side and not also from their side? Because when you're actually presenting a preamble, you need to give a balance of what you're actually addressing, what are the issues, because there are those concerns that have been raised by several parliaments. If you read most of them, they actually feel like there's a lot of influence from external that is threatening their democracy space. And you may need actually to make sure that these principles and guidelines actually try to look into some of those issues. It's just my submission also.
I think that's duly noted. We'll look into it, and I've noted it down. Any other concerns, contributions on the preamble? So I'm taking all the views and I'm trying to note them down with pen, because I think I'm faster that way. Yes,
Just a small one. Sometimes it's the issues of civic space are issues. It's only that we are struggling whether they should be, they apply to the whole region or not. But sometimes one of the terminologies that I don't see there, that can also be one you can consider that neutralizes some of the observations is acknowledging. Because I'm looking at the protocol, they went on to say, acknowledging that corruption undermines good governance, which includes principles of accountability and transparency. So you're still stating the problem, but maybe instead of using the word consent, you use the word acknowledge. You're still stating the problem. It's only that you're stating it in a way that you acknowledge that these kinds of things might lead to certain negative outcomes. So it's just a suggestion.
Yeah.
I think I associate with the suggestion, because I think we could also try and incorporate the component of the impact or effect of human rights violation in explaining why the situation is concerning, the various linkages between rights violations and the impact, for instance, on women, children, in terms of development, in terms of economic emancipation. So that in the end, even where your concern is raised, the evidence is what the negative effect of rights violation in society and on citizens.
I think that helps to really improve the preamble, especially these areas of concern. So I think that we'll be able to recast them. Very importantly, I think that with all the...
Sorry, Nandi. I think I would want to reference you to the position paper when we did the GBV model law. I really like the way they captured, even the model law itself, they captured the impact of negative impact of human rights violation in the various dimensions, whether economic, political. It may help us to be concise in terms of capturing and balancing as discussed by the court.
Okay, so any other, yes, I see.
Oh, fine. I was just curious on the wording where we are saying noting the special position that parliaments play. I was wondering if there's any way we could maybe strengthen the language there. I don't know what others would think of on the phrasing that we have there, special position. Could we maybe recast?
Maybe we can put oversight role.
I think we'll try to find maybe stronger language.
We put oversight role than the special position.
I think the essence of the paragraph was to really highlight that parliaments have got a unique role or a special role or a standing out role, so to speak. I think if we say oversight role, it will be, yes, in general terms. So I've noted the word unique, and I think if it's accepted, that is one we can use. Yes, sir.
Sorry, I'm not picking up a very big difference between the what the message is in the first noting and the second noting. If you can maybe just explain the distinction that you were trying to capture between those two.
I think that one term has to be removed. In the first one, we're really trying to capture the critical role in terms of parliaments as institutions. But in the second one, I think what needs to be removed is parliaments, because we're also trying to personalize it to parliaments in addressing. I think there was a concern at first that was raised about whether individual parliamentarians are also a target. So in the second one, we were trying to be personal and personalize it. And the idea was to ensure that we have two standout paragraphs in the preamble that speaks to parliaments as institutions or as arms of government, but also a paragraph that speaks to parliamentarians themselves and just to capture that essence and to make it stand out. We are still on the preamble and have much ground to cover.
So maybe on that second point, because yes, it's a repetition there, we can recognize the role of the parliament in the creation and probably the maintenance of these, what do you call them, these institutions, the oversight institution, the anti-corruption bodies, etc., etc. Because that is not coming out in the first. The fundamental role in the creation and the maintenance of the effective functioning of bodies and institutions for the protection and promotion of human rights, something like that. Yeah, like these human rights, what do you call them? These human rights commissions, human rights committees, yeah.
If you recognize parliamentarians, you could also just qualify it and say as representatives or as elected representatives. Then you give that nuance in terms of context.
Yes.
As well.
Maybe the word representative will make it okay. But because some of them are not elected, right?
As representative.
They are appointed.
How are they designated?
They're appointed. So it's like we need to make sure that it's all inclusive term. Yeah, so because some are appointed, some are elected, so we need to find an inclusive word that makes sure that everyone will say it's only for the appointed one, it's not for us who are elected, who are appointed.
The appointed ones represent the appointees, the ones that are appointed.
I think we would like to be moving. Maybe we could move to the next part if there are no other concerns with respect to the preamble. I think that what we have done is we've noted the areas that it needs to be improved. So I think with the notes I have and with the notes here, I think we'll be able to recast, strengthen and concretize the preamble and make it a bit more chronological from what I hear. Even some of the other paragraphs that haven't been touched may need to be recast so that everything can flow quite well together. So I have noted that, and I think we'll be able to do that with the team. So thank you very much. I think those contributions will really help us to strengthen the preamble. Like I said, the preamble should capture the essence of the document. So there are a number of points that have been noted that will be included in the preamble just to strengthen it. So we can then move on to the introduction of the document. Basically, we were just trying to introduce the document in terms of what it says. The duty to respect, protect, and promote human rights is primarily owed by the state. This is because it is states that sign and ratify international and regional human rights treaties. In general, the duty to respect and protect human rights falls on the executive arm of government. The duty to protect human rights is a special duty that falls on parliaments and parliamentarians. The duty to protect human rights ensures that the state, through parliaments, enact laws that ensure the enjoyment of human rights, as well as ensure that citizens have a remedy. And maybe we can start here and flag this. ensure citizens have a remedy when those rights are violated. The role of parliaments to protect human rights transcends the enactment of laws that ensure the enjoyment of those rights and the provision of a remedy. It also entails, among other things, that parliaments enact laws that strengthen democratic and oversight institutions such as offices of the Ombudsman, public protector, national human rights institutions, and independent election management bodies. I think this is what was meant in terms of including some of these aspects in the preamble. And I think it will sit well when the preamble is strengthened. Parliaments also play a critical role in ensuring that civil society and human rights defenders are able to carry out their work in a favorable legal environment by making laws. I think this sentence seems to be a bit hanging. In this light, the protection and promotion of human rights is central to the role that parliaments and parliamentarians, it's supposed to be parliamentarians, play in their respective nations. The centrality of the promotion and protection. Sorry? And how do others feel about this?
I think odd is correct. Yeah.
Yes, yeah. If you owe a duty, so it's, yeah. Yeah, I think that we were trying to be.
Is that not remedied by
The word
reference
primary.
to primarily? No.
So that's why I highlighted it. I saw a hand.
I'm going to propose that we take out independent from, it does remain with the election management bodies. Because
Okay.
already independent is a type, but then if you want to be general, it's election management bodies.
How do?
Yeah, in fact, yeah, because there are different types. She comes from the sector, so there are typologies.
Okay.
So there will be a model which is not an independent type.
Okay. Okay. Duly noted. Yes.
Maybe perhaps before we proceed, when you look at the second, is it third line? In general, the second sentence. This is because it is states that sign and ratify international and regional human rights treaties. Now, the duty does not fall on the state based on international instruments. It's primarily on national legislation. So international instruments may provide a normative standard or a normative framework from which to draw when, say, drafting national legislation. But primarily, the duty of parliaments is drawn from national laws. So I don't think that statement is a true reflection of the source of the mandate that falls on parliament.
Which you said the second sentence.
Yes.
This
So
is because
says,
it is states that sign and ratify international and regional human rights treaties.
yes. So read independent of the first sentence, it makes sense. But as a build up to the first sentence, where you're saying the primary responsibility is owed by the state, and we agreed on that. Now, to then say this is because you're saying the basis for that primary duty are international instruments, which may not be a true reflection of why it is that parliaments have the mandates that they have.
Okay, I see. I think that we're coming from the fact that the duty to respect, protect, and fulfill, and this language comes from international treaties more than from constitutions. So, but I think we can.
No, I think Prof is right. And I think what is problematic with this, with the second sentence, is only those three words. This is because. If we remove this is because, the whole thing is correct. In fact, should be reflected as well.
Any other on the introduction? Yes, sir.
The statement starting with centrality, paragraph 2. Of course, the centrality of the promotion and protection of human rights in SADC-PF's mandate is enshrined in Article 6 of its constitution, which stipulates that one of the forum's objectives is, I don't know if maybe it can be split, the sentence. Because I think it starts from
the centrality of the promotion and protection of human rights in SADC's PF mandate is enshrined in Article 6 of its constitution.
Full stop.
Full stop.
Yeah. Maybe it stipulates.
This stipulates that.
Okay. It's
Originally, I had a problem with the use of the word the forum's objective, primarily because in the acronyms, of course, SADC-PF is there, but there isn't any statement that says where you use the forum, you're referring to SADC-PF. So it's better to stick to either its mandate or SADC-PF's. So that I'm just playing a devil's advocate that
Okay.
one reading through it.
Will not
For us, it
understand
is
the-
clear where you say forum,
yes,
they will immediately say SADC Parliamentary
Yes,
Forum.
yes.
Yeah. So if it's done in a way that one is clear that we're still sticking to SADC-PF.
Okay, so it stipulates that one of the objectives of that.
The rest is still okay. He's simply referring to the forum.
Would this be okay?
How about maybe this instead of it? So it will read the centrality of the promotion and protection of human rights in SADC-PF's mandate is enshrined in Article 6C of its constitution. This stipulates that one out. And not it.
It, yes.
Thank you.
This stipulates that one of the objectives of the Does that read well? Does that read well?
Not really. I think we've already established that the subject is the SADC-PF. So when you repeat SADC-PF
This
again,
stipulates
that's, yeah. So that the subject has already been established as SADC-PF. So you can simply say the forums and the subject remains the same.
Yeah, there was a concern that maybe the people may not understand what forum we're talking about. Because in the
Perhaps-
acronyms, we didn't use it.
So perhaps that would have been the case if it was in a different context,
Yes,
on a different page,
yeah,
but now
that's
it
what I
immediately
thought.
follows. It's like
Yeah.
saying Landy, and then they have to say he is. It cannot be a he in page on page one.
Exactly.
What about it? Because there was also a suggestion that we can use it.
So I think that the continuation refers to the SADC PF. When you say it, you're now referring to the SADC PF, and what you want to refer to is the section, which is Article 6C.
Just a question. I know you were playing devil's advocate, and I would like to move with time. Is it really possible that someone would be lost if they read forum here? Because I think from a linguistic point of view, would someone really be lost if they say this stipulates that one of the forum's objectives, would they really be lost, bearing in mind the nature of the document? And
Can also indicate that somewhere that forum is also synonymous with SADC PF.
Mm.
That will help. So that way you make it
yes, I think so too. So any other concerns on the introduction?
Landy. Sorry, before I miss my point, I'm not going to talk about the grammar. I think you might have mentioned that you are going to align the what we discussed in the preamble to the introduction as well, because that introduction, I think it needs to also sit into the context. My point in the preamble, say something about the global and the continental frameworks and commitments before we narrow to SADC. For example, like in 2013, is it the UN Human Rights Council? They acknowledged the role of Parliament in overseeing, the domestication of these international treaties. So there are all these lots of acknowledgements or a recognition of Parliament's role in issues around human rights. So I think the first paragraph to give us that kind of broader, issues around human rights and commitments global and continental.
The global, continental, and then we come to the regional. That's the flow.
Yes,
Yeah.
I think that flow will start from the preamble. As I say, moving from the general to the particular, and then with the introduction as well, we can also move from the general to the particular. And I think that will capture the essence.
You come to Graham wants to speak for the global and continental. I'll speak for the regional. Even before we come to the regional, to SADC PF at regional level, the primary instrument, which is the SADC treaty, is also clear about human rights obligation. Let's buttress that. Then SADC PF is like operationalizing from the treaty.
No, I think I take that. This reminds me of one of my first lessons in sociology, where the lecturer taught us that when you're writing, always make sure you remember that you start from the general to the particular, but there's always something general in the particular, and there's always something strange in the familiar. So I think that we'll capture that. We will capture what is strange and what is familiar to us, but also something that is particular in the general. I think it will help enrich the document. So maybe we can move to.
Maybe before we do, if tea is ready, we can have a health break. In having a health break, let's also have a group photograph. Tea is ready, Landy. So
Okay.
we
I
stand
think we
down.
can. Unless we feel strongly to leave right now, I would have loved that we just finish this section on about SADC PF, but we drew this really from the SADC website and document itself. So if there are any changes, I think they will come from Secretariat, but we didn't want to impose what we are saying about the SADC PF. We got it from the SADC PF website and the information. And we put it there for a particular reason. We think that tools like this do not only circulate among members of parliament, they circulate in the wider human rights space. And I think it's always an opportunity to explain what the SADC PF is about, what it seeks to do, and why it is coming up with these documents. So it's always, we saw it as an important awareness opportunity for the wider readership. And so we put it there. And I will not be able to answer questions as to why that is there or why that is not there. But if there are any concerns, I think that Crusher will very ably be able to respond to them.
I think as it is, we fine unless there are additions.
Is Comoros not a member?
Not yet. They are a member of SADC, not yet a member of SADC PF.
Okay, so how do we want to make reference to that? No? What in future they join?
They join after it is adopted. They accede and we acknowledge.
Oh, okay.
I take it that
in our case at the EC of SADC, both Madagascar and Comoros are not members.
Okay,
So
Madagascar.
every time we talk about EMBs in the SADC region, we make reference to say except Comoros, and so that the document covers that.
Okay, just in case the question. I mean, it doesn't harm to indicate that the 16th member, not Comoros, is not
at the time was not a member.
So yeah, we want to we just do an additional sentence there to
I think there are no other concerns, so we can simply break for tea. 10 minutes, 15.
We are going for group photograph.
Group photo.
Maybe we can do 15.
Or maybe let's aim to be back at 11 hours. It's 10:43 now.
It's at the entrance, so there's a cover. Or if not, we can take inside. But we need the first. So colleagues, Unaro will guide us in terms of where we will have the group photograph. It's raining and he talks to the rainmakers.
Welcome back, ladies and gentlemen. I think we can continue. We had left off from about SADC PF, and I think the only addition or the only concern and contribution was to add except Comoros and Madagascar. I was trying to capture how the actual language is, and how I look at it is it simply adds these words as it is here now.
It was only Comoros, not Madagascar.
It was only Comoros. Oh yeah, it was Madagascar. Except for Comoros, yes. So I think we move on to the next section, which is section one of the principles and guidelines. So I will simply start with the overall intention and purpose of this particular section. We were at pains as to what the nature of the content or the depth of the contents of the document would be, because we were tempted, as the case may be, to go straight into discussing the principles and guidelines for parliamentarians. But we thought that it would be important to discuss the basic nature of human rights for parliamentarians, bearing in mind parliamentary literacy in terms of human rights. So this section simply speaks to human rights duties and obligations, and what it tries to do in looking at the duties of the state in human rights, it tries to locate the role of parliament in human rights. So I think that drawing from the lessons learned in the morning, instead of reading, I will speak to the object and purpose of the specific section. So paragraph 1, which is definition and nature of human rights, really seeks to introduce to parliamentarians and parliaments what human rights are, their philosophical, their normative, and their legal nature, and really just to introduce parliamentarians to this concept of human rights, so that as they go through the guidelines, they can have an understanding of the concept of human rights. I don't even know whether concept is the right term when it comes to human rights, but they can have an understanding of what human rights are. And then 2 seeks to explain who has the duty, and this is the duty of ensuring that human rights are enjoyed. We were using the word enjoyed very deliberately, because the discourse is respect, protect, and fulfill, but also others. I was looking at the UN terminology for human rights, for non-human rights lawyers, and they like to use the word enjoy, because it kind of communicates it kind of communicates an easy understanding of respect, protect, and fulfill. So that is why we're using the word enjoy. So we really here we're just trying to highlight the fact that there are specific duties by different arms of government to ensure that human rights are enjoyed. And on this part, we're also trying to locate the role of Parliament in terms of ensuring that citizens and everyone enjoys human rights. There was a concern that we have been consistently using the word citizen, and that we should find a way of being all-encompassing, because there are migrants and asylum seekers, refugees, and so on. So I think that language will change. And then we also wanted to highlight the obligations of the state, the specific nature of the obligations, that is the obligation to respect, the obligation to protect, the obligation to fulfill human rights. And in so doing, we're really just trying to locate the role of Parliament in the duty to respect, the duty to protect, and the duty to fulfill. I will not go to the duty, duties of rights holders under the African Charter, because that's very specific. But in general terms, this is what this part seeks to do. So I think we can speak to the definition and who has the duty to ensure human rights are enjoyed and obligations of the state arising from human rights. I'm proceeding from the assumption that we had occasion to read the document and that if there were any concerns noted, then they can be raised now on these three parts. Yes, Prof.
Thank you. Starting with the definition, I just wanted to propose, and this is of course subject to how you feel about it and what other members of this sitting feel about that I want to say. So there is generally also a feeling that there is a Western conceptualization of what human rights are. And at times in trying to break down the philosophical foundations, there's a need to try and Africanize it. And the easy way out has been to link the philosophical foundations of entitlement to concepts such as Ubuntu and Boto and so forth. So I think there may be value in you including something to that effect, just to try and make it relatable. So what we are going to look at going forward, the right to dignity that you discuss in principle 3, human dignity, has a very huge correlation with Ubuntu. And in an African setting, African context, African conversation, there's been a deliberate intention to always bring in Ubuntu, Ubuntu, to try and make it relatable, make it something that people can identify. In other circles, this has been termed, say, decolonization, the philosophical foundations of human rights. But I think for this purpose, just making reference to that and bringing in that notion so that people also have a part of themselves in the document. Thank you.
I think that is very well noted and a very important point to sort of give it a homegrown feel, like the African Union has tried with the African Charter. So I think we can also borrow, if I hear you correctly, borrow from the understanding and what the AU has tried to do, especially in coming up with the charter, to make sure that it is a document that is not really Western based, but also to just make it identifiable in our own African context. I think that is also important in explaining the definition here. So very well noted. I've just taken note of that. Is there any other concerns? Yes, ma'am.
Oh. Sorry. Just to pick up on what my colleague said earlier, in general, where you refer to citizens, maybe we want to rephrase that and include stateless persons.
I think we have noted it, and when we sit, one of the things we want to do is to actually capture everyone and edit the whole document. And so it's deliberate that we're not making some of the edits here, but we're noting them down so that we can capture the whole essence. But I think that's a very valid, important point that consistently comes out. And then there was a gentleman there. And,
yeah, I wanted to question on the issue of citizens alone, because one of the biggest challenges that we do have also in Southern Africa is refugees and migrants who are not citizens. So when you look in terms of the rights, if you just put it as citizens alone and you leave them, they actually end up even losing those rights. So it's something that you might need to consider. And then where you also put on the first paragraph, I saw where you put race and nation, but you actually omitted the issue of nationality also. There was the discrimination based on race, sex, gender, but we might also need to consider adding nationality also, or your even migration status, whatever. But there are so many issues of rights that are actually there that we are having as a big problem in the region.
Okay, which also speaks to the earlier consent. And I also flag this so that when we review the document, we can also recast it if needs be. I saw another hand.
Hi. I think mine was just to highlight, maybe not for now, but to just think that sentence where you added citizens. I think the reading of the whole sentence in terms of the state being the duty bearer doesn't read very well. The primary duty bearers to ensure that citizens enjoy their rights is on states. If something is not right there, so maybe just look at it.
Okay. Yeah, so the semantics of the sentence, the grammar. Okay, I will flag it and I'll note that. Any other concerns?
I know this one is a sensitive issue. The LGBTI, where do we fit them? On the groupings. Is it under sex or?
The definition and nature of human rights also points to the fact that parliaments have a duty to particularly ensure that vulnerable and marginalized groups such as women, children, persons with disabilities, sexual and gender minorities, and internally displaced persons are protected from violation and
Okay, I'm looking at the other paragraph up there, where you list discriminate any person.
It further means that parliaments should, through enactment of laws, ensure that
The first paragraph.
the first paragraph. The one that says the definition.
Where you added nationality.
Okay, so we say sexual orientation and.
If we agree, I'm just bringing it up.
Yeah, I think that we can flag this and as we discuss some of the inputs and contributions from the pre-testing, then maybe we can have a bit more clarity. There were several concerns that were raised. So I think that we just need to have a bit of clarity in terms of the approach that we take. There were two schools of thoughts about it, and we'll get to it when we discuss the particular aspect. Yeah, but I'll put it here. I'll leave it for noting, and I'll flag it in yellow, and then we'll refine the document based on the consensus. So, any other concerns on the definition, the obligations?
I'm not sure if this is an important issue generally, but where we speak of vulnerable and marginalized, the listing there is what we all know. But do we want to include the aged? Because nowhere do I see anything, the aged.
It's elderly persons, right? I think that's the UN language. Would that suffice?
On the duty to ensure the enjoyment of human rights, I think your entry point should be the principle of separation of powers there, because it is pretty much what you then go on to say from, I think, third sentence. But if that is made clear from the beginning that the duty to ensure the enjoyment of human rights is tied to the three arms of the state is outlined under the principle of the separation of powers, then that becomes easy for you when you then say parliaments, because we've already established they're part of the arms of the state, particularly because you have said that duty primarily rests on states. Then you break it down in terms of how states are composed.
Okay, I think I'll note that. And that's very important because really the essence of this part was trying to ensure that the role of parliament is highlighted, and that really speaks to the principle of separation of power. And I think we'll do that. Any other concerns? I was trying to find out if using the word elderly persons would address the concerns of aged persons, because I think that the conventions speak to the rights of elderly persons, and I don't think they use the word aged. So maybe in just being consistent with what the different conventions say, we could use that terminology as well. Okay, so again, we are looking at two aspects. So definition, who has the duty to ensure human rights enjoyed, and the different obligations of the states that arise in the obligation to respect, protect, and fulfill. And before we move to duties of rights holders under the African Charter. So are there any other concerns on this specific part? I see a hand.
Oh, no, sorry, Linda. I just did a quick search. So it appears it's the rights of older persons.
I think that that captures the essence, and thank you very much for that. So we're still on this too. Maybe we can move. I see no other contributions. So under this part, we're really trying to do, maybe here we may need to recast it again, bearing in mind the contributions that were made, that we start from the global, go to the regional, and from the regional, we go to the sub-regional. But the idea here was to really start with the African human rights system, and then go to, and contextualize the guidelines and principles within the African human rights system. So we were trying to be deliberate in not using the international human rights system under the UN. We just felt that because it is an African document, we start from there, but also bearing in mind that most countries within the sub-region are member states of different human rights treaties under the UN. But we are also trying to borrow from the practice of the African Commission on Human and People's Rights, where they just go straight into talking about the African human rights system when they're coming up with their principles and documents and model laws. So we thought it would be a good idea to be consistent with that practice. But suffice to say that it really speaks about the duties of rights holders under the African human rights system. And also because it's very unique only to our system. So I thought that it would be an important aspect that shouldn't be missed out, unless it is felt that the concept of duties doesn't fall in this document. Any contributions? Remember, the flow is on the obligations of the state, but when we talk about duties, we can only have reliance to the African human rights system because it's only the African Charter that talks about duties. And so that is why we felt that after looking at those obligations, we speak about duties and we borrow from the jurisprudence of the African human rights system. So we did include the aspect of duties, but again, it was also just trying to ensure that, you know, the document has this homegrown feel, which I'm very glad came out. And I think that when we when we refine the definition, I think we can have reference also to part 4 of the document that speaks to duties. Another aspect is the right to an effective remedy. Here really, I think it's quite self-speaking. It's that when violations occur, those whose rights have been violated have a right to an effective remedy as an important principle. So part of the reasoning was to ensure that when parliamentarians or parliaments are looking at this, they know that within the drafting process or within the lawmaking process, they should provide for adequate remedies to be made to litigants or complainants, as the case may be. But because there's been a tendency not to provide remedies. I come from a country where when the state has been taken to court and the decision has been made against the state, it is an option of the state to respect the decision of the court, and the state cannot be compelled to act on the decision that has been made. And I think that that has been a common provision. I don't know whether it permeates in all the other countries, but I think in trying to be progressive and creating gold standards, I think this borrows from the international framework. Then, of course, there are questions of, can a member state restrict human rights? And here we're just trying to talk about clawback clauses, the right to specific norm-based limitation, using the general limitation clause. Basically, we're just trying to talk about how rights or the enjoyments of rights can be limited. Again, we are communicating to parliamentarians and members of parliament that there are specific but very legitimate defined circumstances under which rights can be restricted or can be limited from being enjoyed. We thought that this is a very important aspect to add. So I'll leave it here for now and invite contributions on these other 3 aspects. That is the duties of rights holders under the African Charter, the right to an effective remedy, and can a member state restrict human rights? We're talking about clawback clauses, the rights to specific norm-based limitations, and using general limitations. So before we get to reservations, so I'll get back to here. Maybe let me try and move this just to make it neater. Do we feel that it is important to add the aspect of duties in the general conceptualization or concept of human rights? Remember, section 1 really just tries to communicate what human rights are to parliaments. And one of the aspects of human rights is the obligations. But do we feel that the concept of duties should be reflected in the document? Yes, Prof.
I think it's a valuable inclusion. In the manner in which it is presented, it does not suggest perhaps that the individual and the state are at the same level. So I think that is important, because once that line is blurred and the suggestion is made that an individual has pretty much the same burden as does the state, then that can be a little bit problematic. I think it does come across that the individual is not as burdened as the state. If you may maybe just make that express.
Yeah, I think that is noted. We'll relook at how the charter recast puts it, because that was the attempt here. So we really just borrowed from the language of the charter. But I think we can also borrow from the normative explanation, maybe from the general comment, so that we can develop and highlight that point. Any other? Any other contributions, especially on duties under the African human rights system?
Sorry, may I take you back to paragraph 3? You cited a few examples under those various obligations.
Paragraph 3 on page
4 onwards.
4 onwards, okay.
Further up.
Is it this one?
No, further up, paragraph 3. Am I looking at the different document?
Is it
Carry
here?
on. It speaks about the duties.
Oh,
I'm sorry, the obligations.
oh, the obligations, okay.
Yes, those. Yes. Yeah, those. So I don't know. I just feel that some of the examples are not so clear that have been included to highlight your interpretation of the obligations. So maybe you can just give some thought to that. But in particular, my concern arises because this document is going to be read by a wide spectrum of stakeholders. So on page 4 at the bottom, is your page numbering different?
It
Which
could
is
be
under-
because I was trying to move so that when we
Okay,
look
yeah,
at
the
it,
obligation to protect. Sorry, I think, so the right to education, where your cursor is right now, the right to education. So I don't understand the next sentence, what exactly you are, what exactly is being said there, because you speak about protection from indoctrination by third parties, and here you cite the parents and teachers. What sort of situation did you have in mind there?
okay. I think we'll recast it. The only reason we use this is that it consistently comes out from UN documents. So we were trying to borrow it, but I get the point, but maybe we can use a different example with respect to the right to education.
Yeah, I mean, is it an issue within our that children should be protected from indoctrination by their parents? I mean, I'm a parent and I'm not happy to read that because
yes.
So that's my one comment. My other comment is I'm not sure about other countries, but in South Africa, I mean, traditionally, when we speak about domestic violence, we always think of the woman as the victim. But increasingly in South Africa, men are becoming victims of domestic violence. The tables have shifted. Women are now the primary breadwinners or the householders. The men's role has shifted in some respects. Men are now the so-called house husbands and become victims of domestic violence as well. So I don't know if we want to shift our terminology to recognize that, and whether it is important for other SADC countries as well, that dynamic.
Okay, so what is the feeling on that proposal? I feel like I should get one or two more views with respect to the contribution on domestic violence, and I think that it will also inform the language going forward. If there are none, any other, but I think we take note of that. It's an issue of detail. I think that requires just sitting down, thinking through, and putting into the document. On the duties, are there any other contributions, any other concerns? Yes, sir.
Just a small comment on the domestic violence. Does it alter the meaning of the sentence, or does it dilute it if we just stop at domestic violence? Or that by limiting it, maybe it maybe brings other forms of violence that are not supposed to have been construed by that statement?
I think it helps. I think it helps to just delete and leave it at that.
Maybe you can also put domestic violence and other forms of violence also.
So
we can borrow from the model law on GBV.
Yes, yeah. I think we'll borrow from the model law on GBV. So can we progress? Are there any other concerns? We looked at duties, and one of the concerns that was raised is that we should create the dichotomy in terms of hierarchy and nature of importance of the duties of the individuals and the duties of the state. that has been noted. And so we'll try to recast that. We talked about an effective remedy, and let me put that just for highlighting. But are there any other contributions before we move to the next part, which talks about reservations? Again, here we're just trying to be very brief, just to say that under international law, states are permitted to issue declarations to exclude or modify the legal effect of certain provisions of human rights treaties. And, you know, these are known as the reservations. And also the legal nature of what a reservation is, but we didn't want to get into the actual detail because this is not a critical part of the report. But also I should be honest that we didn't want to encourage parliamentarians to enter into reservations. So we tried to be very mild on it. If anything, we could have removed it, but I don't know how fair we would be. But I think that to just be honest about the whole nature, we include it there without encouraging them. So that is why it looks like that. But I think this won't really invite much debate. If that is the case, then maybe we can. Yes,
Is there a particular reason why you limit your scope to international law in terms of restrictions of human rights?
Not really. I think we were just, when we use international law here, we use it in the generic sense because it's been argued, for example, that so long as there's 3 countries, it's international. So that is where we were borrowing it. We're trying to avoid saying under international, regional, and sub-regional. So we're just trying to say international law.
Okay, perhaps my question stems from, say, limitations in relation to socio-economic rights. You find internal clauses like within available resources, progressive realization, and the likes, and that is borrowed primarily from the International Labour Organization conventions. And it also constitutes, in my interpretation, a restriction. So in essence, perhaps what I'm saying is maybe you may want to consider adding progressive realization and within available resources as internal limitations that are often attached to socio-economic rights.
Yeah, very duly noted. I think when we look at one of the duties of Parliament in the allocation of resources, maybe we can raise that. Yeah. So shall we move to the principles themselves? In its in its most basic of basic natures, this document contains 3 main substantive parts. That is section 2, which talks about the fundamental principles, section 3, which talks about the guidelines, and section 4, which talks about how these principles and guidelines can be implemented. So in section 2, we try to capture the main human rights principles. So the first principle that we capture is the principle of equality, and I believe this requires no explanation. It didn't invite much the critical feedback from the pre-testing, save for the fact, of course, that we should use the word everyone where we use citizen. But in general terms, the principle of equality was welcome. And here we use the word citizen again. I think that was the major issue that came out. So I'll invite comments with regard to the principles of equality as it reads.
I'm happy with the wording.
One other concern was with regard to the reading of the first sentence. The principle of equality entails that all human beings are the same and should be treated equally. There was a feeling that the word "the same" here, is concerning. So maybe we could say that the principle of equality entails that all human beings should be treated equally, but that also for me is a bit problematic. I think there should be a foundational aspect before we say they should be treated equally. But what can we use in place of "are the same" without using the word "are equal"? Because we use it later. During the pre-testing, there was a concern or two that the word "the same" there is not. My synonyms are very yeah. With documents like this, there is always a temptation to use words that are less simple. But I also bear in mind that the primary audience is members of parliament, and in drafting the principles and guidelines, I was putting myself in the position of the least educated member of parliament. What word would they understand? So, and I know that maybe that drafting philosophy may not have been very consistent, because sometimes you use hard words and it's hard to get away from them. And sometimes you use simple, but I thought when you say human rights are same, maybe it will capture a meaning, that the least human rights literate member of parliament would get, and therefore should be treated equally. I thought the compound of the sentence would capture the essence, but I think we still invite. Yes,
I think the word "some" is what justifies the existence of that sentence, because take it away and you could very well start by saying the principle of equality is founded on the fundamental, which is the second sentence. The principle of equality is founded on the fundamental nature of humanity, and then you continue in that line. So the word "some" there is what justifies the existence of that sentence, because you're simply saying, what, we're the same, and there's a context to it, which is the second and third sentence. So for me, that does the job as is.
Thank you very much. Is that the overall feeling?
Would it shift your intention if we said all human beings have the same rights?
Yes, it would, because before we get to rights, we get to just human beings being human beings, and therefore holding the same rights. So I think that it's again, I would like to use the sameness of us as human beings, because then it speaks to equality, which is same rights, non-discrimination, no one should be discriminated, human dignity, and all those. So it's this humanity, so to speak, this common humanity that we have that I think is very, very foundational to explaining the concept of equality and all these other concepts. So, but I think the question is the sentence ambiguous? If it is not, then maybe.
Would it had to use "same" and then qualify it somehow, say in brackets, so that the reader knows exactly what is intended? Same, and then not one being above the other, something like that.
I think I benefited from the context. It was a really political interpretation. I don't think that we need to go beyond the arguments we proffered. Again, to the extent that it is the language you even find in the Universal Declaration of Human Rights, I think we can proceed on that basis.
And I think, as Prof said, there's context. We're not reading the sentence in isolation. We're reading it as a paragraph. So I think it captures the essence, maybe. So that is that on the principle of equality. In summary, that parliaments should ensure that the principle of equality is reflected in all laws. This is really just a summary. Yeah, so I think that sits comfortably. The second principle, grounded on the principle of equality, is obviously the principle of non-discrimination. And I think this requires no explanation. One of the issues that arose on non-discrimination, also tied to another principle of universality, and I'll speak to it again when I talk about universality, is the one, it was felt that we should not use the term HIV status, but rather we should use health status. But our response was that we're trying to be very deliberate, because HIV is an institutionalized form of discrimination, but that instead of taking it out, we'll put HIV status and add health status. It was also felt that other status would cover sexual orientation and gender identity. But I should hasten to say that when we got back to non-discrimination, it was when we were looking at universality. So maybe we can get there. But in principle, equality, non-discrimination was accepted as as an issue.
On HIV status, is it not another independent area of discrimination, which is also very contentious? I mean, for me, it's good when it's reflected like this, because it communicates a lot. I know of situations where people with positive status were being discriminated, and leaders and politicians not understanding that discriminating people with the status is criminalizing the ordinary behavior. So I think when it is reflected like this, it is very helpful.
Yes, indeed, that was exactly our point. And so we felt that if we dilute it under health status, it will not capture the unique nature of the unfortunate discrimination on the basis of HIV status. It was also felt that we should expand. So there were two schools of thought, and I think when we get to universality, maybe we can have this conversation, but the issue of what gender discrimination means. So maybe when we get to universality, we can have that discussion, but mainly that non-discrimination should permeate through the law. We didn't have many other concerns. There were several comments that were made with respect to non-discrimination, but none with the effect of changing the actual content, except for those two issues. I see a hand there.
Thanks. I really like the fact that you bring out the issue of intersectionality. But I'm just wondering where we have placed it, whether the parliamentarians will make the link between the fact that you highlight intersectionality at the end and that the examples that you give above, those examples are actually examples of what intersectionality entails. Maybe just think about maybe whether or not we would want to sort of introduce intersectionality before the examples so that we make the link. I don't know if you see what I mean. Because you're essentially saying that women are not the same, that there are intersectionalities, and those are the intersectionalities. As such, parliaments must be alive to the potential intersectionality, but you can only know that if you understand what intersectionality is.
Okay. So that is really a question of clarity to ensure that the flow is good, and I think that is a welcome contribution. And I think we can take that into account. I'll flag it and note it. Any other on non-discrimination? We were in principle agreed. There was also the question that when we're talking about non-discrimination, we should include in the paragraph or the explanatory note the aspect of positive discrimination, because here we're only talking about negative discrimination. But that an explanatory note on positive discrimination must be made.
Yeah, and as you are writing that, I was looking at the provision in the Constitution of Lesotho and how that has been interpreted by the courts, where it says the discrimination is okay insofar as it is justifiable in a democratic society. You see, that justifiability is very subjective, because there was a time where a male voter was prohibited from contesting local government elections in a particular electoral division, because that electoral division fell under those which were earmarked for women. You see? So the court said it is justifiable in a democratic society. And yesterday, there was a court case where a group of believers challenged COVID-19 provisions, where the government was saying, if you have not taken vaccination for reasons other than the doctor's permission, you will not be allowed access to certain public places. So the court made a ruling that insofar as those provisions were only considering doctors' permission as an exception, not other considerations, they were illegal. But there was also a minority judgment by the Chief Justice who said that it's justifiable in a democratic society. So I think when it comes to positive discrimination, I don't know, because that justifiability in a democratic society is called positive discrimination. And I don't know whether when we accept that there is something called positive discrimination, are we also not saying there is positive inequality? There is positive something.
I think that very importantly, to avoid subjectivities, we could also just focus in terms of positive discrimination on the normative framework that exists. That is, again, to bring certain groups, marginalized groups, from the margins to the center. For example, an example that I think we can use in terms of positive discrimination that we have, for example, in Zambia, is where you have a situation where girls between a specific age marginalized, they are unable to go to school because of the structure. But you reduce the cutoff point, the pass mark, so that you can bring more into the education system. So that is one of the policies that was made to ensure that, so in short, you reduce the entry requirement into schools for young girls. That is a positive discrimination policy. Of course, it has got its contestations and arguments, but I think it also speaks to equity as well as equality. So, but I don't know whether that example in Lesotho captures positive discrimination quite well. I think it's other subject.
Hey, so I was going to just suggest that maybe we refer to it as affirmative action, because saying positive discrimination will open it up to debate. But what essentially we're saying is that affirmative action is a positive thing and it does not constitute discrimination, right? So I think it's a matter of formulation. And then perhaps we may then want to just simply state somewhere, refer to the issues of overt or de jure discrimination. It's just to explain the fact that there can be overt discrimination, then there can be discrimination that's based on your own internal perceptions, right? And I think that can be very relevant for parliamentarians. We could figure out how to put that there somewhere. Yeah, thanks.
No, thank you very much. I think it's duly noted. If there are none, then maybe we can move to the principle of universality. I think more than anything else, and I'd really like to borrow from the words of the SG this morning in capturing the principle of universality, that because human beings are the same everywhere, human rights are the same everywhere, everyone has in abstract terms, the same claim to rights, regardless of the lived experiences. And that is what we, in essence, wanted to capture. The only concern that arose here was the issue of cultural relativism and whether we should rather look at human rights from a relativist point of view or from a universality point of view. But our understanding was drawn from the Universal Declaration, which universalizes human rights rather than makes them relative, because human beings are not relative in nature. Our inherent nature is quite universal, and that is what we wanted to capture. So I think that was a major issue. There were specific examples that were given, but I think we can overcome those examples if we agree on the on the content of universality.
Thank you. I think universality is preferable because it casts it in that staunch, unshakable form. This is what human rights are. However, I'm also sympathetic to the view that it would be a fallacy for us to look away from the fact that they are not universally applied, as that sentence would suggest. So perhaps we can maintain our universality and how you framed it, but add a third paragraph, which then alludes to cultural nuances and localized interpretations and localized approaches. And I'll be cautious not to provide a proposal there because it's the tricky terrain.
Generally, that is the worry, because we do not want the discussion to be about the exception, but about the rule. And so just trying to focus on the rule without really bringing out what the exception are. Because again, the primary audience are people who do not have a certain level of human rights and literacy. So what you want to entrench are not the philosophical academic debates about it, but just the main principle. I would even be more comfortable to remove human rights are not relative to culture, nationality, and demographic. I would be comfortable to remove it. But if it does arise, maybe, yes, you can have a discourse, but what you want to achieve is to entrench the principle and not the exceptions. Because usually when we do that, then the discussion becomes about the exception, and that is what subsumes the whole understanding of the principle. So I would be more comfortable to even just remove those.
Land. I mean, benefiting from the context in which even the question emanated, I'm inclined to agree with you. Because you then invite unnecessary debate. I think the reflection really was more of the reflection of what is lacking from the move of the motion and in terms of understanding the issue of human rights than the fact that that warrants inclusion. So I agree, and I would propose, in the absence of violent opposition, that we go by your proposal.
I think that really helps, especially for first timers. It's the principle that we want to communicate, and I think there was nothing more raised with respect to universality. Of course, as I stated, there was an array of examples that were given, but really it was whether we should capture universality as a principle or relativism. But I think the feeling is it's universality that should be captured, because I mean, I don't see even an instrument that talks about relativism. It's the concept of universality. With that, we can move to the principle of human dignity. I always stutter when I get to human dignity because of its academic contestations from my other life. But in essence, I think we want to just cover the fact that human beings have equal worth. And that is where the concept of human dignity comes from. We would benefit from contributions in terms of whether we have covered it very well, we've captured the concept of dignity very well. But I think that it is really about the equal worth of human beings. And here we use equal worth and not the same, because we are now getting into the actual intricate nature of human beings. So we're not saying human beings are the same, but it's about now the actual worth and so on. So there was that deliberateness to use this term as opposed to the same, because at this point, readers would have been accustomed or would have been brought to a certain level of understanding. So human dignity, again, did not invite so many challenges. I think it was quite well accepted. It was one of the most well accepted.
I'm sorry.
You may proceed.
Okay, thanks. In your first line on that paragraph, did you mean that it is not undermined, or did you mean that it is underpinned? Where you say worth and value is undermined, first line of that paragraph, yeah. Not undermined, or is underpinned. Okay.
Reminded that there was an issue that arose.
No, just reminding that when we talked about dignity, that's where previously Dr. Nwe raised the issue of Ubuntu.
Oh yes. And I think that maybe we can address it here also, to borrow from when we were talking about the introduction and we raised the concept of Ubuntu. I think that we can now cast a light on it here. I think let me just make a note of that, So because I think it was an agreement, it was an agreed position of the House that we talk about Ubuntu in the introduction and also in the definition section. So we can cast the light on it just here on the concept of human dignity and how it really permeates through this principle. I think that's very important.
Sorry, can I just take you to the, in your second paragraph
Yes, sir.
there, parliaments should ensure. For me, the word impact simply means affect. So can you perhaps include the word negatively impact?
Parliaments should also ensure that all historical, colonial, cultural, and current laws and policies that negatively affect.
Yeah, or negatively impact.
We'll see what we can. On human rights, dignity are repealed. Okay. Think negatively impact. Yeah, negatively impact. Thank you. I think that's very important. Negative impact on human dignity must be repealed. And I think we all know what this this sentence tries to capture from our shared history. Then if there, oh, two hands there.
Sorry. I think when I take you back to the previous
Principle.
that last sentence.
Universality.
Yeah, the
Okay.
last sentence, the last.
The role of parliament is to ensure that the laws are made in a way that human rights are universally recognized, that no rights are ignored or viewed as rights for other geographics or demographics.
No, yeah, I think it's before that.
Not the one before or this one?
Before the last sentence, right?
In essence, the principle of universality entails that the rights enjoyed by citizens in one member state of SADC are and should be the same as those in other countries. The concern would be, it's vague in my mind, but I can see what it would invite. I can see it. Yeah.
So is that, and also the last sentence which talks about geographics. I wouldn't use geographics there.
Yes, I can see where the concern is, and I can't put a finger to it, but I can see. I can see, and I agree.
See what you're inviting.
Yeah, I can see what you're inviting.
Should it be in essence or ideally?
Ideally is quite good, but I think in essence speaks to, it cements that the principle is, it's what it is. It's not, it's what it is. It may be outside the lived experience, but it is what it is. In essence, we are the same. Ideally, we are the same. In essence, we are the same. It's just, but sorry, I didn't get that.
No, I'm just picking on what he has said. So the geographics issue in the same sentence above, you could make the same point. We can recast, but not mention that the rights should be the same from one member state to another, perhaps eliminate that and just have stated simply what is the issue.
So can I just read it so that I can get, the role of parliament is to ensure that the laws are made in a way that human rights are universally recognized, that no rights are ignored or viewed as rights for other. So remember what we are really trying to achieve here, and I like to borrow from the SG, from the first day. We're trying to create a gold standard. The gold standard should be that, that universality should be, permeate. So where it's a principle, it's, and in coming up with a principle, you really want to, I don't know whether you want to reach for the stars, but whatever is beyond the stars, so that at that point, when parliamentarians are debating laws, they won't say, these are, we don't talk about internet as a right here, we're in Africa, and so on. We're just trying to reach that gold standard. The lived experience and the practicalities may be different when we go down, but when we're handing it to them, we're not trying to make excuses for them and give, that we understand what the pragmatic situation is. And so because of that, we'll leave it here, but hope is not a strategy. So that is, well, that was the essence of this paragraph. But I think, yes, we need to reformulate it.
I'm just laughing because I'm surprised that colleagues are seeing the political mischief that parliamentarians would start raising before they grasp the essence of.
Yes.
So the call for juxtaposition, for comparison, while intended to emphasize universality, it will invoke what we don't intend. Whether you are oriented to think in terms of political rights or you are thinking of socioeconomic rights, you place yourself from one extreme end of the member states to the other, and in the end, not focus on what we're trying to communicate. So if there is a way of capturing it without necessarily having to go down to one member state against the other, that in essence is the prayer.
It will be like, what defines that benchmark? Which country, has the benchmark? Yeah.
It might help to just sit on this just for another minute. I think it's important. So through it, universality means that human rights are the same everywhere for everyone. The fact that human rights are born, human beings are born equal, any prohibition on the ground of discrimination. In essence, the principle of universality entails that would it help to say, in essence, the principle of universality entails that people within the sub-region enjoy the same rights everywhere, or would that still be problematic? The guidelines on the Public Order Act of the AU use the language that the rights enjoyed in one country should be the same as the other, and so on. When I read it, I did raise the same, the same antennas as what we're raising now, but I was like, okay, I'm sure the document went through a certain process and they must have found why they were adopting this example. I think this is really a textbook example, but I don't know whether From an academic point of view, it makes a lot of sense, but I don't know from a political point of view whether it's how we should cast it. So we must be alive to that. I think that is what we're trying to say here.
When Nandi says, let's spare a moment reflecting on it, he's simply saying, may you propose counter
Yes.
text for the same.
Indeed. Thank you very much.
Additionally, there is a proposal you had given, I think for the last sentence, a specific one, and then I didn't internalize, but I remember you saying something.
For the geographic. No, okay. I was saying whether that couldn't be captured by some, not other.
I am thinking if we find a way of recasting this sentence in essence very well, we might as well lose the last one. If we capture this sentence very, very well, we might as well lose the last one because the essence of the two is just to communicate the same thing. So maybe what we would want to focus on is how can we recast it? Maybe we could say for purposes of progress, we move, but with the rider that we think through how we can recast this sentence, we'll also think through it.
Except that the last sentence was specifically on what the Parliament must do to realize this principle.
I think I was thinking that in recasting it, we really then also capture that, strengthen the same position, and then just take comfort from the summary principle. Parliaments should ensure that the principle of universality is reflected in laws. But in flagging it, we're not flagging to forget. We're flagging to think through, but we're just moving for purposes of progress. But I think this is a very, very important aspect which I see can really invite serious debates. It is such parts of a document that can even invite non-acceptance of the whole document, because once someone is dissatisfied, and I'm thinking about members of parliament here, you can lose them, because some of these aspects really speak to deeply entrenched beliefs, positions, and so on. So I think we dealt with the issue of human dignity, and then we went to, we spoke of minority rights. A number of issues arose again, but of course, we were asked, why do you want to include minority rights in the, sorry.
Can I just take you back a little bit? And you can highlight it for thinking and recasting later on the previous paragraph. Yeah. Just go up a bit more on human dignity. So the last paragraph, that parliaments must play an oversight role on the executive to ensure that conditions of living, conditions of service, such as healthcare and even condition of detention for offender are at a minimum standard for the human condition. I don't know, what are we trying to articulate? Are we trying to give them examples as well? So one is the grammar itself, but I think maybe just if you can just explain a bit more what we want to say, then it might help us. Maybe we might need to rephrase a bit.
Okay, I think that what we're trying to say is that Parliament does play a role in ensuring that there are specific minimum standards in executive-run institutions such as hospitals, detention centers, and even in for example, living conditions such as housing. So we know that it is a prerogative of the executive to, to run these institutions, that parliaments must either through lawmaking play a role in ensuring that specific minimum standards are maintained. And that is what we're trying to communicate. I don't know whether it captures the essence, but if not, then I think we can recapture it and ensure that the grammar speaks to what we're trying to communicate. Yes,
I think the intended point is clear. It's the grammar that needs a bit of attention, but yeah.
I agree. I think that we can attend to that. So yeah, I think that reading it really, you do feel it needs to be recast, and I agree. So I think that I'll flag it as such. They say that when you go on someone's desk, never move it around so much. If a person works on a messy desk, don't move something. They will know that you have moved something. So also if someone looks at my document, don't remove the stars. I know what they mean. There's always that feeling. So, when you try to own a document, you really try to know what you have communicated to yourself, and making sure that you have changes. So we, if no other concerns, we can move to the principle of minority rights. In explaining the principle.
Sorry.
Oh,
okay. I think I agree with him that maybe it's the expression, but I think it's beyond that. And Graham is going to help with my point on this issue.
Yes,
right?
yes, indeed.
Because I think beyond the grammar, there's something we are trying to ask Parliament to do here, to adopt a lens that helps them look at issues in a broader way, right? That as you play your oversight role, that you need to look at human rights, ensure that human rights standards, whether in development, in conditions of service, are met or are considered. That's what I was thinking about essentially, because here we then mention a few examples, right? Conditions of living, healthcare, but it's broader than this. There are other aspects because the spectrum of the issues that they're going to look at goes beyond this. So how can we capture that in such a way that it encapsulates all that, right? I don't know if that makes sense, something like that, but it can be for later thinking, just hoping.
I think I get the point that there is a greater role beyond, but I think we're really saying the same thing. I think what Prof and what you have said in a way says the same thing. It's about finding a way of recapturing the sentence, because really what it simply tries to say is that there is a role that Parliament can play in ensuring human dignity, and that one aspect of human dignity is conditions of living. But in saying conditions of living, it's not as captured in the text, but your life experiences must be at a certain minimum. I mean, you should have a certain minimum of healthcare, a certain minimum of conditions of detention and all these things. And that, there should be a normative framework that Parliament can look to in trying to achieve that for the executive. So yeah, I get it. But also, as we make these contributions, I also invite that we continuously think through them, so that when even after the validation process and as we enrich the document, you can also reach out and just be able to send those concerns and those contributions when we think through them a bit more deeply, so that we can capture them when we are refining the documents. So hopefully the contributions from the floor during the validation will not be it, but that when we think of these and we, maybe tonight or at some point, especially when they are fresh, they can be sent to us and we can use them. We'll really benefit, from those contributions, even outside. And now, after all, we're all members of the technical working group to a certain extent. So I think it would be very, very helpful to have that, especially when you have that, oh, moment, I forgot to add that, let it not be a conversation at the bar. Let it be a subject of an email. Because we always, there's something about that report. There was this and that. I think send an email. It will be very helpful. Graham, you're on the floor.
No, I just wanted in addition to what she has said, as you are reflecting, most of those minimum standards are prescribed, isn't it? Like conditions of detention. So maybe they are prescribed according to, sorry, Kuraja would say he loves going global. But there are these international frameworks that kind of provides these minimum standards, so that like you don't run also into questions or conversations around what is minimal. Right? You got it? Yes.
We'll try to use this language. So I'll just put it there for further reflection, but capturing this particular essence of prescribed normative frameworks, their normative standard normative contents. I think that's and that's what we tried to achieve. We were trying to communicate here, but again, I think it's now becoming more clear that we need to just improve the drafting and also the grammar of the paragraph. So I think, thank you very much for that. We would have lost this, actually. I would have lost it. Is there any other on human dignity? If not, then I'll get to minority rights. We're trying to explain an important point that but others call it the minority rights thesis, but there is always a tendency to talk about human rights in terms of the majority, and that is what really is the practice. But of course, we cannot talk about human rights without talking about marginalized and vulnerable groups or minority groups, whichever way you want to define minority groups, but the focus really is on marginalized and vulnerable groups. And we're trying to say that there should be deliberate efforts, and there is a role that parliaments can play in ensuring that the rights of minorities are also respected, protected, and fulfilled. We narrowed it down also in the text to specific groups. What came out from the pre-testing was that we have narrowed this scope here, and that it should be expanded. Of course, what we are trying to do is really just offer examples. But I think that I will invite questions and then juxtapose those questions with some of the issues that arose, because I suspect that we may have similar concerns. Any concern in terms of what we're trying to achieve in highlighting the fact that parliaments have a role to ensure that minority rights are protected. Yes, Prof.
Thank you. I think in trying to provide examples, you run the risk of either being minimalistic in your approach or opening yourself up to, well, some of these are society-based, you know, and reading that, I thought perhaps you can leave it at marginalized and vulnerable groups and do away with the examples. That was my so it's either you do away with the examples or you expand them. But again, my discomfort stems from the contentious nature of some of the examples. So if, for instance, you say disability, sexual and gender minorities, that becomes a conversation on its own. So I would alternatively say as such, parliaments should ensure that marginalized and vulnerable groups are specifically protected in legislation. Then national legislation then
say that again. As such, parliaments should
ensure that marginalized and vulnerable groups are specifically protected in legislation.
Okay, and then we have parliaments should therefore adopt legislation that specifically prohibit discrimination against these groups and specifically protects their rights. Further, parliaments should provide mechanisms to redress when violations occur. So I would have also just, in adopting your earlier proposal, left it here and then hope that the second paragraph captures that essence. How do we feel about that?
Linda, I think I really agree with this point. It's quite pertinent and adopted, but just on the first sentence to say, if you can just say, I don't think we say right of minority, we say right of minorities, right? So maybe if we can capture it accurately on the protection of the rights of minorities.
What is the feeling? Okay, I'll also just counter check the overall language. Also, I think that it is important to note that the model law says that member states will define in their legislation the vulnerable and marginalized groups. So when we leave it like that, of course, this document will not be just read in isolation. And so I think the model law kind of also captures some of the essence of these concerns. So if we leave it here, I think then we'll just be speaking to what the model law says and without being simplistic or then being too expansive that we cannot be expansive. Because once you open that door, then you are open all sorts of conversations, and I think this captures the essence. Then we move to principle 6, which is a human rights-based approach. We were really just trying to state that there is a normative standard for a human rights-based approach, or there is what is called a human rights-based approach. I know that Some human rights people don't even like the term human rights-based approach because they say, what is it? But it is actually there. And what we're just trying to capture here is that in the lawmaking process, there are aspects of laws that should invite parliaments or parliamentarians to include or entrench a human rights-based approach. And there are several examples that we can give. The example that I gave is, for example, when it comes to non-state actors, there's different laws on investment, laws of mining, laws of land allocation, and so on and so forth. But when those laws are made from a purely commercial investment and economic point of view, you leave the people that those laws will affect, especially when it comes to how resources can be allocated. So you come up with a mine in a national park, for example, just as what we are experiencing. The people in that area are going to be affected in several ways. They're going to be displaced. Maybe their water, sources of water will be affected. But a human rights-based approach is one that the decision to be displaced, the decision to have your whole livelihood be affected should be with the people. But this comes from the backdrop of such practices within the continent and the sub-region because of, how the need for development can kind of override, the human rights of citizens, and we just displace, no conversation and so on. So that was the spirit in which we tried to include the human rights-based approach. Granted that maybe we didn't communicate 100% what we wanted to say, because maybe the example then becomes what it should be. But really, it's just that the principle of a human rights-based approach in terms of informed consent, accountability, a remedy, adequate compensation is captured. So I welcome contributions on how we can enrich this part. That's perfect.
Just grammatical issues again. First paragraph, the second line from the bottom, I think it should be debating investment laws. So laws should come after investments. Investment laws. And then in the same sentence, in such a way that all forms of investments do not negatively, you remove regulated by the law, because every business transaction, is regulated by the law. And then the third paragraph, the second paragraph, a human rights-based approach furthermore ensures that people know about their rights and can claim them. The subject is the person, so human rights, they perhaps about their rights and can claim them. So we do away with human.
A general question: do we agree with the principle that a human rights-based approach sits well in these guidelines and principles? So I asked the question because there was a sort of mild contribution that no, the human rights-based approach should be subsumed in citizen participation, but I think we all know that there is quite a different and there's a difference between the two. And otherwise you then have effective participation, very broad and so on. But a human rights-based approach, I think it's quite different. And the African Commission is building in its jurisprudence, growing on a human rights-based approach, also, parallel to its jurisprudence on effective participation of citizens. So I think it also sits quite well. And with that note, if there's nothing on a human rights-based approach, we could look at effective citizen participation and then break off for lunch, because we're almost getting to lunch, and hopefully be able to move faster. So effective citizen participation, again, we're really just trying to talk about the fact that citizens should be able to participate in the governance of their country, in decision-making processes, in the legislative process, that even when parliamentarians are representatives of the people, they should still defer, or rather they should still be mechanisms through which the representees play a role in the lawmaking process. And I think that is giving the right to participation, but also giving an accountability to the right to representation. So that is where this one sits. I don't know whether we are concerned with the use of the word citizen here, or it is very contextual. Then the concern that came is this, the word government. Someone felt, or one or two people felt, that this means that citizens should be in government, that they should be ministers. And so they said we should find another way of explaining this, because it means that their citizens are also part of government in the formal sense.
And would the word governance address that?
I kind of propose that, but I look at the words almost the same, government, governance, but governance maybe, but yeah, before we agree, what's the feeling? I think we can start with this. Is it ambiguous? It was felt that government is not the correct term, and maybe governance would be.
Or could it be public affairs?
Yes. Oh, yes.
I think that the starting point is to ask ourselves, what sort of participation do we have in mind? What sort of, not what we have in mind, but how do citizens participate? So this is through public hearings, through consultations, and so forth. They have no direct participation in the policies and decisions that are made in the implementation of those policies and how government decides to do certain things. So if we say governance, then we all have an understanding that this is in terms of, first, electing public representatives, and secondly, being available to be consulted when public hearings are undertaken. So I think for me, governance would be the word.
I also second, I think even the contestation was more of where they were viewing government, in this case, as a noun, when in fact it is not about the government as a noun. So governance then takes care of that potential ambiguity.
Okay. I think that we know what we want to say. Maybe it's just about having to recast it.
Mine is more of a recommendation. I'm thinking of civic education, where it comes in relation to this aspect. Role of Parliament in promoting civic education, something like that. Thank you.
I think that because these are principles and guidelines for the promotion, I think that so the aspect of this effective participation can be brought out in two ways. One, in ensuring that the right to participation is protected through mechanisms, but two, that the right to participation is promoted through civic education. So I think the civic education will speak to the promotional aspect, and then the participation will speak to generally the protection aspect. So I agree that I think that there is something missing. So we could add civic education as a promotional aspect that Parliament can play. What have I done? So I think that will help. I think we can really recast it. So effective citizen participation. Others actually even had concerns with the use of the word participation, but alternatives could not be offered. But the argument was, look, these are the words that are used in human rights discourse. We cannot run away from participation, because I felt, but when they're participating, are they sitting in offices? Are they, you know, you don't want to say it, but then you realize that there is also need going forward to, you know, kind of entrench this human rights language in different stakeholders and end users of the document, because there are certain words that are really, you know, grounded in human rights language that you can't change. I don't take it that people will have concerns over the use of the word participation here. Yeah. If that is the case, then we can proceed. I'm happy that we've made these changes, and I think there is a synergy between what's coming out here and what came out from the pre-testing. Maybe we could just finish on political and social participation of an independent civil society movement. Then we can move neatly to the guidelines, which is the next part, so that we can finish with the principles. So here we're just simply talking about political and social participation of an independent civil society movement, really trying to highlight the fact that civil society plays a key role in the protection and promotion of human rights, and that a conducive environment should be made for civil society participation, civil society inclusion, also for example, in the lawmaking process. But really, it was simply meant to capture the essence of the role of civil society in the human rights space. No, I think that I just want us to finish this one. I don't see that it will invite so many contestations. Then just after that, we get into the guidelines so that we don't get back to the principles. It's the last one. Yeah.
maybe just have a look at the summary principle. It might not articulate what we want to say exactly, just some grammar issues. Parliament should ensure that civic space is free and that civil society participates in the process of, what did we want to say, legislation making? Just more clarity on our principle so that it's easily understood. I kept thinking about our document on whether or not it's gender blind, etc. And I was just thinking about civil society and was there ever a conversation of where we are locating gender equality advocates or women's rights organizations, etc. Just food for thought maybe as we go through the rest of the document, because I think where it's possible for us to engender it more, perhaps we should just about.
Yes, I think we can also flag that. And when we look at the guidelines, I think maybe we can also bring that to the fore. It did arise, but the general feeling also during the pre-testing was that when we're looking at principles, some of the gendered aspects are included, but I mean, that's subject to our decision. But there is a specific part where we talk about mainstreaming and trying to gender the document. Already today, there was a concern of why we are putting, why we're specifically mentioning women human rights defenders. So that was sort of the feeling. And so to capture that balance, we tried. Youth advocates will tell us, but are you ageists? So striking a balance also is always good, but I understand the point.
Landy, maybe, okay, I was whispering to Maureen to say, maybe we could recommend a standalone principle that speaks to gender, rather than, like trying to go through the document and do some symbolic, throwing of words there. Just make a deliberate effort and come up with a standalone principle. It might not be a long paragraph.
Okay, I think we should be able to do that, and we can further entrench and agree on that in principle when we look at the guidelines. We did have
we can give you the text, the two of us.
Oh, great. Remember, we said that those emails must come, so we'll be welcoming that email. I think at this point we can neatly move to lunch and then get back and then start looking at the guidelines and hopefully conclude in time. So thank you very much for this very, very fruitful and enriching process. I think the document already looks like it's going to be quite concretized. So thank you so much. I leave it to Krusha too.
Thanks, Nandi. We must thank you too, having thanked us. I think you are driving the ship. Do you drive a ship? Yes, whatever he's doing to the ship, but he's doing it well. And let's enjoy our lunch. We reconvene at 2:05, so that, but we can even convene at 2. Yeah, we're not politicians. So we can convene at 2 so that we proceed. We are hoping to be joined by SADC Lawyers Association and Amnesty International after lunch. One will be physical, the other one will be online. Enjoy your lunch.
Thank you.
Thank you. Maybe before we start, Landy, wanted to check, Tigeri, are you able to hear me?
Yes, I can hear you, Mr. Kurasha.
Thank you very much. We want to welcome you to the meeting. We have the Secretary General and colleagues from the SADC Parliamentary Forum Secretariat, then members of the Technical Working Group for the Democratization, Governance and Human Rights Standing Committee. And we're considering as we communicated, the knowledge tool on the role of Parliament in the promotion and protection of human rights. We are honored to have Amnesty International participating, and thank you for considering our plea. I do know that we had a communication gap with Depros moving on, and he had been serving on the Technical Working Group, and we hope that you will permanently occupy the seat. I've been informed that you are currently the acting director. We shall delete the acting and make sure that you are directing very soon. Thank you very much. We appreciate.
Thank you very much. And yes, apologies for the communication breakdown. But I just want to say thank you. We appreciate your consideration for bringing us in. And yeah, good afternoon to the Secretary General, to the honorables and all colleagues in the room. I'm very honored to be part of deliberations. Thank you very much, Mr. Kurasha.
And thank you very much. I think welcome back, ladies and gentlemen. We continue where we left off from. We have since looked at the principles, and now we are transcending to look at the guidelines. So we now start looking at the guidelines, and we'll continue with the same modus operandi, where we just speak to the overall object and intention of the guideline, and we invite comments from the floor, and we also have online participants, so you're also welcome to just chip in. Perhaps what I don't know how we could, but maybe just by raising your hand would be helpful. I'll be able to take note of it and invite you to make your comment and contribution. So, like I said, and not to be repetitive, but these principles and guidelines are broken down into two. The first aspects were the principles, and now we look at section 3, which is the guidelines. The guidelines we tried as much as possible to be less abstract and a bit more practical, to work as a guide into how can those principles be actualized. And so we'll just get into the content, and we'll speak to the intention of each of the guidelines that we provide. So the first of the guidelines was ensuring the representative nature of parliaments. The reasoning there was that as we start, it's like a housekeeping guideline that parliaments in and of themselves must be representative, and that democratic nature of parliaments should be the first order of the day. So we know that parliaments are already existing, but we want to entrench the principle of representativeness by parliaments, because only when parliaments are actually representative will they then be able to carry out their mandate in line with the wishes and manifest will of the people that they represent. So hence that that guideline, so I will invite some comments. And Tigero, you are welcome to raise your hand on each. I don't know whether you have the document in front of you. Okay. So there is only one concern that arose with respect to ensuring the representative nature of parliament. And that was that if you look at paragraph 2, it focuses on the conduct of local, regional, it focuses on parliamentary elections rather. So there was a suggestion that we should be deliberate and say and talk about a presidential, parliamentary and local based elections to be exact. So that was the proposal, so that we don't focus only on parliament. And this was with respect to the fact that one of the ways in which the representative nature of parliament is ensured is through free, fair and regular elections. And attached to that is ensuring that the election observers and monitors locally from within the jurisdiction, and then the regional and international observers. So it was felt that we should be very deliberate when we talk about elections. Any takes on this principle, on this guideline rather? So I in reading, and I would like to be guided here. In reading, when I look at the second paragraph, parliaments may further ensure that the conduct of elections, local, regional, and international observers are not restricted. I felt that maybe it doesn't correlate very well with the second paragraph. I think that the issue of the legal environment can come out in the very first paragraph as well, to ensure that parliaments are not going to election centers, but what their role is to ensure that it is the legal framework that ensures that local, regional, and international observers work within a non-restrictive environment, but a very enabling environment. So that's what I wanted to capture. But when I read it now, I feel like maybe I didn't capture it as well. I don't know whether that's the feeling, but I feel like it can be recast better.
Hi, Linda. I agree actually, because I kept thinking, how do parliamentarians ensure? How do you actually ensure that the conduct of elections or the role of election observers is respected, or that they're given that scope? I was grappling a bit with that. Would it be in another normative framework, ACTEC or something? I don't know. In addition to their lawmaking role, maybe.
Yes, I think that's the essence that this should capture, because electoral laws are really one of the cardinal aspects of democracy, and it's parliamentarians it's parliaments that make them. So sometimes you find that they are very restrictive in their nature. We had a debate, for example, if I were to give Zambia as an example, as to whether we should have international observers or whether we should have monitors. And the discourse just went to international. We should only have international observers. We should not have monitors. So you have these things, and that is why we talk about the shrinking democratic space, because again, hope is not a strategy. So you can have a government that will say, I think for us international, we only have international election monitors. We can swing to any direction. But I think in this guideline, we really want to capture that essence, that in the lawmaking process, electoral laws should ensure that we have international, regional, local election observers and monitors. And I think monitors should be added here.
So before you add them, and do they exist? Where are these monitors? Yeah, because I think they've literally been phased out, the monitors, unless we want to reinvent them and bring them, because they're largely restricted to countries in transition, or because even for domestic observers, they are also have to be called domestic observers and not monitors anymore. So I think we can live without having to add monitors and not lose anything. The second point I was going to raise is the biggest role of Parliament is with regards to ensuring the existence of a legal framework that makes it possible for the country to hold free and fair elections. I think then the participation of the legal framework in facilitating participation of observers is part of that package of making sure that the legislative framework facilitates for free and fair and many other terms that are used. I do know that there are constitutional provisions that are very specific around that. If we can couch it in that way, and then the issue of observation is an addition, because observation on its own is exactly that. So it may not necessarily on its own add to the essence of the principle. So let the emphasis be about creating a legislative framework that facilitates for credible elections, including participation of different stakeholders, because it's not just observers, it's actually a barrage of stakeholders, and Hilda would agree. Thanks, Chair.
No, thank you very much. Very well noted. I think that that's what would capture the essence of this aspect.
Do we still want to use free and fair elections? I'm saying this because a lot of organizations now are struggling to account for that terminology. At the electoral commissions, we prefer to use credible or elections with integrity, aspects that we can talk to. But Kurasha would know that now there is no institution that declares elections free and fair. It's difficult. So we may stick to terminology that we can account for. That's one. Two, I don't know if we want to list the elections, the type of election, because now there are also emerging types of elections. We have Lesotho with snap election. We now have by elections. We have yes. So I don't know. I think if I'm to rephrase, I can propose that Parliament must promote election observation in all types of election. Then it's generic, because then national or whatever type of election. But also to add, supporting Kurasha in terms of legal framework. At what point do we talk about promotion, adherence to electoral instruments? I think Parliament has a role, to make sure that as much as we conduct elections, then they must be conducted in adherence to the electoral laws, electoral instruments, like the SADC model law. Yes, thank you.
The whole essence is actually that elections provide an opportunity for the enjoyment of most of those political and civil rights. Hence, the importance of the legal framework to be broad and comprehensive enough to accommodate all these. There are means of realization of many, many rights.
I think how we can capture it is just to add them there. I think what we took primarily the African Charter, that is Article 13, and then we took the principles set in the Charter on Democracy, Elections and Governance. And why we use the word free and fair is that that is the language that is captured in that document, but we can move away from it if the terminology is evolving, so that we can actually just.
In fact, I think what would be useful in guiding the language is the revised principles and guidelines governing democracy. It has gone a long way ahead of the others to deal with exactly the question of free and fair that Hilda was alluding. So even the model law on elections is an enabler for the realization of the principles and guidelines.
Yeah, I think that point is taken, and I think
I'm just wanting to confirm that the guidelines you're referring to are the SADC guidelines. Huh? Now, I was asking Kurash.
Okay, yes, I think he's referring to the SADC guidelines.
Yeah. Okay.
Okay, I think that that is very well noted, and I think my concerns are now addressed. This part can really be enriched in the redrafting phase.
If I may make a general comment. I think one of the things that the arguments we've advanced is that the model laws are a contribution to the growing Bill of Rights at regional level. And when you look at almost all the model laws we've dealt with issues of rights in a very detailed way. And what could help the model law, I mean, the principles and guidelines, just like we have done with the SADC model law and election. Let's borrow from them or reference them where they are helpful in advancing the cause, because they will then speak to what parliamentarians are already familiar with, and more importantly, what is already being used in domesticating some of the principles in member states. Thanks.
Thank you very much for that question. I think that that can also be added in the introduction, just to make certain that this document is not read and is to be interpreted on its own, but that there are supplementary documents and that it can feed off or can feed the model laws. So I think that's very important to note and to expressly state in the guidelines. So the next guideline that we can look at is guaranteeing the sovereignty of Parliament by protecting the freedom of expression of its members. During the drafting phase, it was felt that freedom of expression of members of Parliament is absolutely cardinal to their role as individual members of Parliament to play an effective role in the promotion and protection of human rights, and therefore that they should be given some form of independence, some form of privilege in their expression, of course, within the governed rules. One of the reasons is that we live in a situation where in most countries there is no separation between the executive and the legislature. So you find that ministers are drawn from national assemblies or from parliament, and sometimes because of the way parliaments are structured from the party level, members of parliament are restrained or constrained from speaking out, but that if rules can be made within the house that would be very helpful in ensuring that they can help in the protection of human rights. So one issue that came up from the pre-testing is that we should really speak to, also here on this part, speak about parliamentary procedures in terms of how members of parliament can have their freedom of expression enhanced. So any additions to what came out from the pre-testing or subtraction?
Is it a person of or and?
And.
Remember privileges and immunity.
And so maybe as we think, since it's on the same page, I can move to another guideline, which talks about investing in knowledge and continuous capacity building of parliamentarians. On this one, we took into account the fact that
maybe one quick one, Randy, sorry. You see, the summary is implying that the parliamentarians should institute, laws that will, allow them to enjoy those privileges. But if you look at that text now, it doesn't talk about any kind of legislative process or oversight, where you say members of parliament must be free to seek, receive. What will guarantee that freedom, is the legislation. So maybe to couch it in such a way that they should support, promote, legislations that will enable them. And that will then support that summary guideline.
In fact, I'm just thinking now, Landy, that these whole issues are sufficiently addressed in the benchmarks for democratic legislatures in Southern Africa. They were reflected on and captured quite sufficiently. If you can use that, the language in there is really comprehensive and went through rigorous analysis in terms of the different dimensions we can easily miss while we are doing the analysis. Sure, I'll favor you the code, but it's also on our website.
Okay. Yeah, I think I've noted that, and I think they'll richly inform the document. There is a hand.
Comment on some point that the structure of parliament that we do have are different, right? So it might be tricky to make that, because some of them, like in South Africa, they are not elected by the people, but it's a party. But in other countries where you stand as a member of parliament, it's actually possible. So you find that it's a right of the party to either withdraw you or put you there. So we might need to find a way to encompass all the systems that are prevailing in the region. So maybe what we may refer to the person who developed this, they need to go and check what is actually the practices of the structure of the parliament in the region, and then apply that to the context.
Yeah, I think that would be very helpful to just have a glance at what are the protection mechanisms in the different parliaments, just to sort of have an understanding of how that works in the couching of this particular guideline, and also taking into account what the benchmarks say, so that we can borrow from that language and then input on this particular one, but not only on this, I think on the other guidelines as well.
Yeah, sure. Because the beauty of the benchmarks is that it was born out of consultation by the SADC Parliamentary Forum with all the parliament, and therefore takes care of the different parliamentary solutions. Because they were already saying, despite the differences in the system, there are minimum benchmarks that a functional democratic parliament must have with regard to lawmaking, oversight, representation. So the benchmarks would suffice in terms of helping you to just
recast some of the, So they provide a normative basis in short, which can be used on the different aspects of the guidelines, but also on the principles, I'm sure. So investing in knowledge and continuous capacity building of parliamentarians. So we're still on the same page. This really came out of the understanding of a basic survey on constitutional and human rights literacy among parliamentarians. And whilst we found that there was a level of understanding of human rights and constitutionalism, it remains a concern and therefore a recommended guideline that there should be continuous knowledge building and capacity building of parliamentarians in their understanding of human rights. So if parliamentarians, for example, are to implement these guidelines, it would be very difficult if there is no basic understanding of human rights. And we use the word continuous because we know that parliaments evolve and they change in different countries every 5 years. So it's important that there's a continuous process. The exercise is continuous. So as a way of capacitating them, we thought that this should be one of the guidelines that should inform their work. There was this part. In this regard, all parliaments must conduct regular capacity building trainings, have in stock research resources and an intensive orientation program for new members of parliament. I think there was a proposal that when we use the word parliament here, we should be very careful because we should talk about parliaments as a legislative body, but also parliaments as institutions. And I think we were invited to think of a terminology that would capture both. So the administrative aspect where there should be a library, there should be this and that. So it was felt that maybe if we just use the word parliament, we'll just be talking about the legislative body. But others still felt that, the essence is captured by still using the word. So that's one of the concerns that came out from the pre-testing. If there are any thoughts on that, they're also welcome. If there are none, we can move. But also we can always get back to any of these because I think that they are very, a bit succinct. So it would be easy to get back to them. Ratification of international treaties. So here the essence is really just to say that parliaments play a key role in human rights protection and promotion through the ratification of international treaties. So here we say ratification of regional and international treaties, but for brevity, the title of the guideline is international treaties, but generally is to just encourage parliaments to, as much as possible, ratify treaties. But it also speaks to the aspect of reservations that we talked about. And of course, we don't want to encourage parliaments to put their instruments of reservations because we as much as possible, we want parliaments to be bound by the whole content of the treaty. But that is the principle here. I think it went without much debate. There was a question as to whether ratification is a parliamentary or an executive process, but I think that was cleared. And members who didn't seem to understand were given the clarity. But we think as a guideline, this is one of the most important or cardinal roles that parliaments can play.
Sorry, just to take you back to the previous paragraph, the summary guideline, did you mean to state that it's member states that should have knowledge of the legal framework?
No, parliamentarians. I think we meant parliamentarians here. Yeah. Must have knowledge of the legal framework, parliamentary procedure and international standards and best practices. Yes. And I think this can also be made better. So ratification, I don't know whether this captures the essence or there's more or there should be less. I know that different countries have got different laws on the processes and procedures of ratification of international and regional human rights instruments. So we tried as much as possible to be general, but also just to capture the role that parliaments can play in the ratification process. And the other issue that arose was the second guideline that we'll look at, which is domestication. So it was said, no, you should say ratification and domestication, but we wanted to just state clearly that ratification is one process, domestication is another process. So maybe we can look at them in the same light. Here, domestication is simply to state that one of the roles that parliaments can play is to ensure the domestication of those international treaties so that the international norms and standards can then be localized into local legislation and law. I see a hand.
Yeah, just a small one, whether it should be treaties or instruments, because some are treaties, some are protocols, some are declarations. So maybe a term that can encompass them all.
I think maybe we use instruments. Yeah, so we'll try as much as possible throughout to then use the term instruments as an all-encompassing term, unless there are contrary views.
Maybe where it is specific, referring to maybe a specific treaty, but maybe
Yes,
where
of course.
it might encompass more than treaties, but other declarations, protocols, yeah, conventions.
Indeed, I think that's duly accepted. I'll just note that. So any contribution with respect to domestication? If none, then we can move. I don't know if Tigeri is still with us, just to confirm.
Yes, I am. Yes, I am, and I do agree with using instruments. Thank you.
Thank you very much. Just checking.
Yes, thanks.
So another guideline, and this really speaks to also economic, social, and cultural rights, but of course, civil and political rights. We try to avoid. There are different schools of thought on these aspects. There is a move to try and avoid, the use of civil political rights, but by some because of the nature of state obligations and so on and so forth. I think that's an academic, more for an academic conference than here. Sorry?
The word pressure.
Okay.
I think we need to find a proper term.
Okay. All right. Thank you very much. And that means that we're already into this particular aspect, which is the allocation of resources. And I think it's quite self-speaking, that in looking at laws, in looking at budget approvals, parliaments do play a role in ensuring that there is sufficient resource allocation to different sectors. That is one way of ensuring the fulfillment of rights, at least in particular. So this aspect really speaks to ensuring that there is enough on different aspects. Remember, for example, we talked about dignity and we talked about ensuring healthcare. How the only way that can happen if there is sufficient budgetary allocation to those facilities, to healthcare, to so on, and I think this is a very important aspect. So I don't know whether the reading of the text of this particular guideline speaks to the title of the guideline. If there is none, maybe we will move, but I note from the other concerns that we try to make this particular paragraph a bit consistent with some of the issues that already arose. So I've taken note of that particular paragraph. I see a hand.
I'm just wondering if the summary guideline 6 itself is reading how you intended. If you can just look at it.
I think the word domesticate should perhaps read domestic.
So I think, well, as a standard, we would like parliaments to ensure that resources are allocated to both domestic and international obligations. The idea here is that sometimes a parliament may not domesticate a treaty, and of course they use progressive realization, the language of minimum core obligations and so on, or margin of appreciation. So the idea here was just to try as much as possible to be exact, to say that some of these standards that exist at international level, even if not domesticated, there should be a move by parliament to ensure that resources are allocated based on the international standards, the international framework, so that non-domestication may not be the excuse. In any case, when a state has ratified a treaty, they have expressed their willingness to be bound by the contents of that treaty. So we were trying to be very deliberate in ensuring fulfillment of domestic and international obligations. I think one of the important contributions that came out post the testing was that we should try to also bring out the language that comes from the general comments in terms of allocation of resources and on the other parts. And so we will take that into account really on the nature of state obligations with respect to allocation of resources. I don't know maybe whether that would also help. But does that cover the concern or?
So, sorry, so the issue is not, it's not that countries aren't domesticated. So that's, so here we are assuming that they are domesticated, like the ratified instruments are domesticated.
No. Remember when we started, and I think this will sit neatly with one of with the recommendation that came, that we should have a certain chronology, international, regional, and domestic, or we can say international
Hello, Colette, are you on? Let's press.
Yes, I can hear. Yeah, sound was a problem. Now I can hear. Thank you very much. Thanks so much.
Most welcome, and feel free to participate if you have any comments to make. I want to confirm if Webster had shared with you the document.
Excuse me, I was speaking muted. I'm saying I've got the document. I can't see it clearly on screen. And also the one with the concept and program. So I don't have adequate information. So, yes.
Okay. No, that's fine. Let me attach the version we're working on I do not have your email, but at least I can attach on the chat.
Oh, that's perfect. Excellent. Thank you so much.
Most
It will
welcome.
yeah. So how far, where are you now? I saw very impressive articles there, conducting the missions, routine missions, and also the focal point, civil society presentations of annual reports. So I was just reading this one page. So it's really good, yeah.
Okay, what we'll do is Landu update in terms of where we are so that you are able to follow.
Thank you so much. Thanks.
Thank you very much, and welcome, Colette. So I think that in updating you, it really resonates with really how we get to this part where I was saying that in essence, the principles and guidelines have 4 important parts. The introduction, which really sets the background, and we looked at that. And number 2 is the actual principles, which are really broad thematic or philosophical principles that speak to the protection and promotion of human rights. And 3, then there are the guidelines, which are a bit more pragmatic and practical in terms of what steps can be taken in actualizing what the principles say. And the 4th part speaks to how these guidelines and principles can be implemented. Who is the custodian, and what are the practical steps that will be taken from this point on to ensure the actualization of these guidelines. So we have looked at the introduction. We've also looked at the preamble, the principles, the guidelines, and now we are getting into section 4, which looks at implementing these guidelines. We were of the view that it is important to have a section that talks about how these guidelines can be implemented, or how or what steps will be taken, rather than leaving it just at the principles and the guidelines and then, you know, what next after that. So we have section 4, which speaks to implementing these principles and guidelines. And I think I will run through them briefly, and then Krasha will also be able to provide a bit of meat into what I will say. And then we can move on to another aspect, which is the last one, on specific recommendation for regional stakeholders. And I have a specific point that I want to make, but subject to the guidance of the room on this particular part. So without further ado, there are 3 parts to how these guidelines are to be implemented. But when you unpack them, you see that there is a lot that has to be done. And so in terms of the first one, we look at prioritizing human rights implementation by parliaments. Now, the text speaks to the ownership of the document or custodianship of the document, which will be the SADC PF. So these guidelines and principles will be overseen by the Standing Committee on democratization, governance, and human rights of the SADC PF, the committee shall promote and encourage national parliaments to create parliamentary human rights committees to roll them out within their national parliaments within the composition proposed. But there is an important aspect here. I have flagged or I have highlighted the word in accordance because I don't want it to seem, or I don't know whether we would like it to seem that we are imposing the parliamentary composition and normative framework of the UN, or we are borrowing from it. So in accordance there may seem like it is mandatory, whereas it's more of in reference to, or any other language that may seem less prescriptive of the composition and functions of parliamentary human rights committees. But there is an annexure C there that speaks to that composition, and that is the only normative framework that I saw was agreed even with SADC member states, because it was a Human Rights Council resolution.
Maybe Nandi, before you proceed, I think there was an omission. We also have another structure, which is the Regional Parliamentary Model Laws Oversight Committee, which is a committee of all chairpersons of standing committees. It will be good, given the cross-cutting nature of human rights, to also make sure that besides the Democratization, Governance, and Human Rights Standing Committee, we also entrench the Regional Parliamentary Model Laws Oversight Committee as an important platform or structure to deliver the implementation process.
So I think that we'll liaise on that and ensure that we have it reflected here. So I think that the text speaks to, how the guidelines will be prioritized and what steps SADC PF will take to ensure their actualization, at least on the first part. I see a hand.
Yeah, it's more on the, is it the fourth paragraph, the first sentence towards the end? Should it be in their home parliaments or maybe in their national parliaments or domestic, maybe national?
I think national will capture the essence.
I think land was missing a home
at the time. Indeed, yeah. So that is that is one of the steps. I think there's several content-based steps on prioritizing human rights implementation by parliaments and how the custodianship of SADC PF will be done in terms of these guidelines. Another important step is to capacity building. I think this speaks to the other guideline on capacity buildings of members of parliament. Again, I will allow Prasha to just give a bit more meat to this particular aspect, but it is really that as these guidelines are being rolled out, and that national parliaments are taking them into account and are using, there has to be a level of capacity that is built in the national parliaments to ensure that there is a level of understanding of human rights. So this basically speaks to that. So I will use the last paragraph, which says that the committee shall encourage member parliaments to include training on these principles and guidelines as part of the orientation program of new members of parliament following every general election. So that is one of the, that is one of the practical steps that will be taken to ensure that the guidelines are mainstreamed. So I chose this because it really speaks to the essence of the implementation step of capacity building.
Thanks, Landy. Maybe the additional point I could make in terms of framing the collaboration, the stakeholders may be much broader than the category of entities we have put here. So let's find a way of making sure that we accommodate everyone. Secondly, and also more fundamentally for both points, first point and second point, another important organ to target within the institution is the Committee of Clerks of Parliament. You saw that we deliberately brought them yesterday. They were represented as a Committee of Clerks of Parliament, because part of what we are experiencing is that we capacitate parliamentarians, but sometimes forget the administration of parliament. And yet they are the central point in terms of channeling of resources, prioritization, or surfing of thematic areas of focus. So sometimes they may not be ready to do as much as we expect, simply not because they're not willing, but because they have been left out. I remember when we had the meeting with legal drafters from member parliaments during the model law on election. One of the drafters simply admitted and said, I didn't realize there have been so much developments out there regarding the issue of elections, and yet I'm the one given the task of drafting the law when we want to amend. So it's important that we target the secretariat, because they are the heads of secretariat, so that they are also equally capacitated in order to then facilitate what must happen in national parliaments, particularly if you want to ensure sustainability. Sure.
So are there any recommendations?
Yeah, I just going back to the point that you have mentioned regarding the stakeholders. Have we exhausted all of them? So I do support that contribution, and also basing this on the SADC Declaration Treaty that recognize a range of stakeholders. So it lists them. So I don't know how you can put that, because it's quite a number of them that are regarded as key stakeholders and significant in the process of regional integration.
Now that is duly noted, and I think it resonates with what Prasha said. So there's another hand, I think.
Thanks. Mine is just a question of clarity. I'm wondering whether member parliaments need to mainstream. Do they mainstream? Do they adopt the guidelines? What are we looking at them doing exactly? Because they might want to understand this clearly in order to take it forward. I'm not quite sure myself how what that would look like. And then the second issue is on the capacity building of parliamentarians. And there's a specific mention that some of the capacity building will be based on international principles and norms that have been set out in the guidelines, but there are some that have not been set out. So if I'm thinking of Maputo Protocol and others that are specific to gender and would want capacity building of parliamentarians to be focused on that, or to give due attention to some of those issues, where would that fall? Because then I think it's important, and perhaps it speaks to the guideline we were talking about, or the mainstreaming of agenda issues we were thinking about, but maybe something to pack somewhere. Thanks.
I think that is duly noted, and I think in terms of the capacity building, I think it will be very important to design the material in a broader way, so that you kind of ensure that there is a foundation for human rights understanding in its broader context, but also in the specific pockets and pigeonholes that the different principles sit. And then when you speak about the guidelines, you then locate them more contextually. And I think that these guidelines will really work if there's a level, at least a minimum level of human rights literacy. And I think that is why the issue of capacity building is very, very important. They are quite specific in terms of nature. So really a basic understanding of human rights is very important, because if there is none, I think members of parliament may not even know why should we have such guidelines. You know, there's that type of a foundational issue. But I saw the hand.
Thank you. Just to add that the guidelines can be used as an advocacy tool, where parliaments can use the guidelines to lobby the individual governments. That's what I think.
Indeed, I think that's a very, very important point, and I think it's noted. Parliamentary advocacy is also one of the issues that can come out of these documents.
Maureen, was that a comment or a question in terms of the form, in terms of what form it could take? So the issue is that ordinarily when we adopt regional instruments, the national parliaments will proceed by way of adoption and adaptation based on their context. But I think the emphasis is the outcome in terms of what we want them to do, the mainstreaming. Whether they are mainstreaming this in terms of adopting the framework and then also looking at the structures within parliament where human rights must be mainstreamed. They will really be, they will respond differently, but because there is a formal process of adoption we go through at SADC-PF, the assumption is that when they go back to their national parliaments, where they see relevance, they are able to apply. But what is even more important, which is why we bring stakeholders on board and why I was talking about broadening the stakeholders. When stakeholders are also aware of this effort and the tool, when you engage with parliament, it's easier to start off with such tools where they already have consensus, they've been part of. And we have often been chaffed in instances where we are told 2 weeks later by a stakeholder that we were using your tool in a meeting that we were in with the parliament in Addis Ababa. We forgot to tell you, but we used the tool. So yes. And then, in fact, the whole issue we were talking about also the inclusion of the administrators of parliament in the process of development, so that they also start to figure out how do they mainstream it within the committees of parliament, within the thematic issues that they are dealing with. So I think what is important is bringing the organs on board who can be the vehicle for transmission to the national parliament in order to cascade and filter the domestication at national level. Thanks, Madam President.
I'm sure that that aspect has been adequately covered. The last part is again, I think it reflects one of the guidelines, and that is expert research shall at all times guide the discharge of the functions of the SADC-PF in the implementation and realization of these guidelines. As such, SADC-PF shall engage experts to advise on the human rights impact of model laws, legislation, and policies within the discharge of its duties. Again, I think that more than anything else, I would defer to Crusher on this one. But I think it just speaks to the quality assurance and the quality in the execution and implementation of the guidelines, that they are always guided by knowledge and evidence. And so when it was being discussed, I think that was the sort of the foundation, and also that there will be collaborations with civil society, academia. I think the previous point was to broaden the scope of engagement, and I think this marries well to the scope of engagement. I think more than anything else, this part also speaks to ensuring that the various stakeholders play a critical role in actualizing the guidelines. I think if I've missed out anything, maybe an addition could be made.
Thanks, Landy. One of the things that the current administration of SADC PF has been deliberate on is to create legitimate spaces or on the table for stakeholders to participate in the business of SADC PF. This meeting we are having was budgeted for, planned meticulously, because we believe that there is value in bringing stakeholders on board. And one of the vehicles we want to deliver quality programming across all our programs is through technical working group membership, where we are able to benefit from you as individual experts, but also in terms of your institutional affiliations, where we can see opportunities for partnerships and collaboration. And this, in essence, must be what it is speaking about, where we're looking at broadening the opportunities that exist. Because in terms of opportunities, it's not just money. Sometimes opportunity is about major occurrences that are happening within certain organizations that have linkages. It's not going to be possible for us while sitting in Windhoek to know what South Africa is going through, for instance, which could provide an opportunity which we can ride on to be able to link with the efforts that are already underway. So if we must ask us where we are in terms of what we think we could derive as value from technical working group, we are on 0.1, because there is much more that we think we could get from technical working group membership, which must, one, clear our blind spots, align us with international trends, but also create tables for us, legitimate chairs on the table for us, where you also have space. We've often been left to deal with regional issues, even when there are international processes that we could also be connected to. We would want with human rights to be able to participate in AU processes, for instance, in the UN processes, for instance, and where our membership also benefit in a very direct way in terms of developments that are happening when human rights discourse or human rights issues are being considered. And this is what we have in mind. So it's the intention is really to enhance that collaboration so that it's mutually beneficial, and it helps SADC PF to remain connected with global, regional, and global trends. Thanks, Land.
Thank you very much, Crash, for that clarification. Oh, I see a hand.
I actually really appreciate that that section, and I think it's critical, as you say. But I also like the phrasing that you mentioned before. You said expert knowledge and research, but in this section we've only mentioned expert research, because some of it is not always some of the expertise is not always going to be in research, but it's going to be shared in other means. So maybe we may want to capture that, but just to say that it's really a great input there. Thanks. But not sure we need the word initial, right? Is it adding value for us to say initial expert knowledge, right?
as we correct it, expert knowledge, do we need it?
We need the word initial.
But initial, yes.
Maybe you can explain what.
So the idea was to ensure that, you know, in the actualization, in the implementation, as steps are being taken, there is a level of consultation with experts. So that is that is where the initial comes in. But I can get that in the continuous process. Maybe the initial would be lost, but also to just be very clear and candid that the steps are not just taken without a form of consultation and without a form of knowledge and without a form of collaboration. So I think that is where the initial comes in. We could lose it, but we could also keep it. I don't know what would do most harm.
I propose, because the intention is really on a perpetual continuing basis, initial would make us lose each other trying to understand what exactly we're talking about. And to the extent that we are mentioning civil society and the academia, we can be generous to the technical working group and also identify it as a vehicle or a stakeholder that must also be consulted, because it's a policy entity. It's born out of a deliberate policy position.
Hopefully that kind of gives it a clarity. And from what Krasha has said, I think that we'll also just give a bit more meat on this particular part so that it captures some of the sentiments that are not captured and have been said or addressed here. So if there are no other contributions, there is, we get to the last part of the document, which speaks to specific recommendations for regional stakeholder engagement and advocacy. And I did say that I have an opinion about this particular part. I don't even know where to start to express it.
Start from the beginning.
When I look at the document, in terms of what it seeks to achieve, in terms of the audience, and also bearing in mind that the part on implementation will be enriched with some of the contributions and contents that will come from Croatia and the SADC PF. And I read this part on specific recommendations for regional stakeholders. I know that it has some important points. I think it's about 2 pages. It does have some important points. When after the drafting and some of the reviewers felt that you should have this specific aspect, I sort of got a discomfort, and that discomfort hasn't left me. That's just me being honest to the document. The discomfort didn't leave me because I thought that some of these aspects that are very particular to the stakeholders, and we include, are covered up or could also be subsumed and be made part of the implementation part. So I've often wondered whether we necessarily need to have these recommendations, but you know, when you do a document like this, you cannot run away from part of what reviewers say. But I've often wondered whether the document cannot do what it is intended to do without part 4, which is specific recommendations for regional stakeholders and engagement. So before we get into it, I just would like, how members feel. Yesterday, when we were looking at this part, there was a bit of, a silent questioning of how do these sit in. You could explain, but also because you don't have 100% ownership of this particular part, you're also a bit at pains. But my honest view is that the document can still achieve what it seeks to achieve without this part, but that some of the recommendations from this part can be included in the initial part, which is here, section 4 under 1, and then prioritizing, and then we can have specific sections. There are a number of good proposals, for example, business and human rights and so on and so forth. But I don't know. I see 2 hands.
Thank you. I also got the sense that it's a bit too prescriptive. So it's the sort of thing that gets one in that space where they're thinking, well, this has really narrowed down the space in which I can maneuver, even the sort of things to engage in are prescribed, of which I don't think that is the intended purpose of these guidelines, really. It is to conscientize and nudge in a certain direction, nudge being the keyword. And when you're nudging somebody, you then have to be cautious not to be too prescriptive in what you then, so I saw business and human rights, that is a good, that is a good prescription, but again, you make reference to investment laws somewhere in the initial principles, and that is covered really. So yeah, that is my sense.
Thank you, and I think that it exactly captures the thinking I have. There was a hand behind.
Yeah, I just wanted to check the standing orders of the SADC Parliamentary Forum on how they take recommendations. Are there not action that are based from their council? And then from those recommendations, that's actually how they can action them. So my question would be, if we are going to make this recommendation using this channel, will it be correct protocol-wise, or there's actually a channel that is supposed to be used within the context of SADC Parliament where this need to be discussed and then put as a recommendation, and then from there it takes the procedure within the SADC PF itself. So I would want the guideline to take the role of the standing orders, that is for the SADC PF if these are issues. I don't know, that's my submission, Chair.
Thank you very much, and maybe Krasha will respond to that, but there was a hand that's been
Thank you. I think some of the points have been covered. I was just wondering on the reporting obligation, which, and of course, there's a suggestion to align it to already existing reporting mechanisms. But I think one of the complaints of member states is that they're burdened with reporting. Maybe you can speak a bit more to it. And now, if we want to add that these guidelines are also bringing another reporting burden, I'm not sure how that would sit.
Yes, exactly. Any other contribution with respect to these specific recommendations? I think that the overall feeling is this part is a bit too prescriptive, and we can do without it, but not to throw it away, but where those aspects of these specific recommendations can be used to feed other principles and guidelines, and even the part of implementation, then we can fuse those without necessarily having this overly prescriptive part. I don't know whether that is me concluding and pushing my agenda, or that is me summarizing the views that I get.
I think we share the spirit of the observation, because I do remember that yesterday, one of the things that we got stuck with was this one, enhancing awareness of quasi-judicial character of parliament. And because of the prescriptive nature, first of all, it was anticipating situations that have never arisen in certain parliaments. And as a result, you know how the human mind works. Once they see what they don't like, they get blocked. You are unlikely to engage. So I like the proposal to infuse, but where we can, in very broad terms, because when you look at this, the title then says specific recommendations. I think we read the spirit is to really make it broad rather than specific, because people then will get ideas. Because I can tell you without fear of contradiction, when I have read about this, there's certain things I will say non-applicable, but some will say good idea. So let's couch them. If they can be couched in a broad way, be integrated, but if they are retained, if elements are retained, let them be broad, because often what we also do post-adoption of the tools, we've tried to develop scorecards as one of the ways of tracking implementation. And when you have these broad ideas, it also sometimes help to give the ideas. So I totally agree with the sentiment of the House, and I think it speaks to the spirit of what we're trying to do. Colette is online. Don't forget to recognize if she wants to.
Yes, indeed, Colette. I think that we've been talking about this part. Any views on that?
Yeah, I totally agree with the sentiment shared here, because now this is a guiding tool, which it's going to be used as a source of reference for the functioning of specific activities or duties. Now, the recommendation, it would have, it's something that could have a separate, could be something which is separate, like if it was a statement recommending them to do A, B, C, D. So the way it's crafted here, it's like we are actually not prescriptive, but yes, dictating as well, which it might shoot us on our own feet. So I don't know if we could have a different phrase to couch it in such a way that you don't lose the substance, because those issues are very new and I find them very unique. These routine missions, I think right now at the African Commission, they have what we call the Addis Ababa roadmap. So it's cooperation between regional and international special mandate holders. So they are able to piggyback, especially the regional ones, into the UN to conduct some of the country missions. So I don't know how we can coach this in such a way that these parliamentarians as well do not feel left out or undermined by these regional or international treaty bodies coming in to conduct missions at national level. And reporting as well, civil society. I think for civil society, I found this is a very vital initiative, idea actually, where civil society can have a forum, engagement with them, and present the report on the challenges that we are facing, where the parliamentarians have got a mandate to influence policy, and also at national level, and also at Pan-African parliament level. So I do agree with you, and at the same time, I really I don't know what kind of a heading or how we can best couch them in such a way that we don't lose them. They are loaded and they're unique. They're very special, and I feel that they have they give a sense of participatory way, which is should be well understood for Parliament. Parliament it should be open forum for open processes where stakeholders, various stakeholders can engage political parties, politicians and trade unions as well, and other business. They should be able to access the forum. And the last part, just moving out of this paragraph, is a key mechanism, regional treaties. I see that efforts have been made to include all, particularly at regional level. I was thinking that if we could also add the African Youth Charter as well, be part of those that I mentioned under the region. And then also I thought if we could add the protocol establishing the African Court on Human and People's Rights. Now that it could be a source of reference, because some member states have ratified this. There are state parties and there are some obligations under it. So I thought it was important to add it. And then I see under the international, I was feeling that maybe if we could add, the other one on the region is the SADC Gender Protocol, SADC Gender and Development Protocol, if it could be added there, because that is the prime treaty for us in Southern Africa. And then we have all these, at international, So I think let's leave to this, They are adequate. I don't think we should add others. So that's a bit of a challenge for me as well. But honestly, that resolution it's actually what is needed. It's a matter of finding ways of how to couch that and not to be prescriptive and dictating to them, but finding ways of helping them to move forward. Maybe it can be commitment, can call it our, commit to, I don't know, and or additional guidelines that they can invoke or employ or adopt in the guidelines relates to all this. Thank you.
Thank you very much. I think, Colette, you've also just echoed what the room has said, and thank you also for highlighting some of the instruments that need to be included. I think the general feeling really is that there are specific aspects of the specific recommendations that need to be kept, but they are overly prescriptive nature, and the way they came out really is something that needs to be considered. And I think that where some aspects will be subsumed and incorporated in other parts, will do so, and where there is need then to just enrich this part of implementation, we'll use some of the content here. And I think that in so doing, we'll continuously be in liaise with Russia.
if I may.
Yes.
In fact, when Colette mentioned the African Youth Charter, I then remember that you had the burning issue of youth participation. I think that would be a good source of reference, yeah, to see what we pick from there.
Indeed, and I think that we can also borrow from the jurisprudence of the commission. So we have agreed in principle and in fact that we are going to have a specific guideline and recommendation on youth participation. So I think we in including the African Youth Charter, that will also just resonate with that particular guideline and principle. So we come to the very last part of the document, and this is the annexures. Annexure A speaks to the summary of principles on the role of Parliament in promoting and protecting human rights, bearing in mind what we have discussed. The nature and the casting and the phrasing of the summary principles will obviously change, because the summary principles only just borrow from what was in green. So for example, summary principle 3, Parliament should ensure that ratification of all international and regional human rights. So in the summary, it was as it appears here. But now that it has changed, so this change will be reflected in the summary. So that is the impact of this validation process with respect to the summaries. And summary guidelines for Parliament and okay, so that is the guidelines will also change in the same light.
Just a minor Annex A, summary of principles on the role of Parliament in the promotion
yes.
and protection of
yes, in the continuous tense. So Annex C is a model for parliamentary human rights committees. I think that the annexure will obviously be kept, but we also said that we'll have another resource, and that is the benchmark for democratic parliaments. I think that is also going to be a very important resource. So there'll be another annexure that will really speak to this. Again, we're just trying to, reach for the sky or touch God. So in having both resources, I think there will be no harm, but it will be good for the document. Then the document goes to Annexure D and E, which is core African regional human rights. I think we agreed that we'll be using the word instruments. And there were two that I think it was felt we were missing out. Of course, we'll add where they can be sourced, the African Youth Charter and the SADC Gender Protocol. Are there any other protocols within the SADC region that would wish to add?
We have the the SADC protocol, which I don't know what to say about it. We all know that it's been the physical forum has been disbanded. There's a new protocol which provides interstate litigation or complainants. And ultimately, we still need to have that type of a forum for it to receive complaints on these treaties that the SADC member states have acceded to. I don't know what to say regarding that.
Okay, I think we'll look into it. One of the guides is to ensure that the instrument we cite here speaks also to the content. But I think one that we'll add is the SADC treaty itself. I think we have to include it.
And the protocol on politics, defense, and security cooperation, to the extent that it talks about institutions that must be accountable, upholding human rights, I think it will be an important instrument. I also have in mind the revised principles and guidelines governing democratic elections, to the extent that it is now anchored in the protocol and the treaty, because a lot of the election-related rights, the electoral rights, are entrenched in the revised principles and guidelines.
Okay, that is noted. I think there is more. So I think in essence, there's just a review of the instruments that we'll need.
The protocol that she was referring to, I think it was, I don't know what word you use, but there was a tribunal. It was disbanded. The protocol is no longer.
Oh yeah,
it has been replaced.
We know that one.
Yeah, it has been replaced with another structure, which. Yeah.
No, that one. Yeah. International instruments. I think the list is quite exhaustive. I will try to cover as many of the international instruments because of the normative framework and the normative content that emanates from them. And so we took all the core international human rights instruments. And on this, we just also used the actual UN resource tool on what they define as the core human rights instruments. So I think this is quite exhaustive, unless there's a feeling that there's a particular international instrument that is missing.
Okay, there is only protocols and other international instruments. Huh? Because, yeah, okay, no, it's not relevant.
So with this, we go to the very last page of the document, which is blank, which means that we are done. And I think that in terms of how we conclude the validation exercise, I will leave it to Krasha to then guide us. But I want to say thank you very much. I think the process has been very enriching, and we can all agree that the document will read much better. It has been enriched, it has been concretized and solidified with these contributions today. And that it's a much better document, and we can all share in the experience of coming up with it, of enriching it. And I think it's a document that we can all be proud of having taken part in its formulation and development. So thank you very much for my part.
Thank you very much, Landi, for thanking us, but I think we also should most heartily thank you for the way in which you were gliding. Earlier on, I wanted to be assured by the room whether you drive a ship. I didn't get a response, but that's precisely what he did. He did it so effortlessly, and for henceforth, I will introduce you as a man who needs no introduction. And then copying from politicians, after telling us about a man or a woman who needs no introduction, will take the next 30 minutes introducing the same person. We are grateful for the effort you made. I will not seek to preempt the words of the Secretary General. If I start talking, I'm not privy to the words she intends to say. So avoiding the risk of putting your words into my mouth. We have reached that point when we are concluding part 1 of 2 parts, or day 1 of 2 days. And I think we have done justice to the work we need to do. And at this juncture, it is only appropriate that we invite the Secretary General to deliver closing remarks, and then we will advise on what follows. Over to you, ma'am.
Thank you, Kurasha. I think Mr. Landi deserves another round of applause. He's done a marvelous job. And I must also thank you very much for sitting through, not going to the shops, not closing your eyes, thinking with your eyes open. I want to, on a quite serious note, to thank you for your earnest views and comments that you have made today at this stage of the tool that, as indicated, has your ownership and buy-in. I'd also like to indicate that the issue of human rights is normally not an easy one. Yesterday, when we moved from the one on curbing corruption to the human rights one, you could already see the different views and thoughts and feelings that were looming in the room. Some of it is what you spoke to when we were validating the tool and the sensitivities that you're trying to expunge out of the tool in terms of giving recommendations to Mr. Landi to consider. And I must say that he took those gracefully. And that is why I believe he deserves a round of applause. Colleagues, we all know that human rights, especially socioeconomic rights, are applied at varying degrees in different jurisdictions. And it is positive to know that there's evolution and consensus to respect and protect human rights as a matter of principle. Even if the degree of application may differ between countries, between persons, and parliamentary systems, I'm happy to note that as a technical working group, you agree that they must be upheld. And this is something that will go a long way in assisting and facilitating parliaments to ensure that this is not lost at any point. We are also cognizant that at the regional level, it is already a huge achievement to agree on base principles, with steps to be made ahead being earmarked through progressive future initiatives. And I looked at how you highlighted your recommendation page, Mr. Landi, and I could feel your heart thump from where you're sitting. It is quite progressive, but because of the nature of progress that needs to be incremental and introduced in the most sensitive, somebody said, would it help if we indicated that sensitive laws or discriminatory laws? It just shows the level of maturity that the technical working group and wisdom that I've extended to you today. There's no doubt that there's a significant work that we still have to do, that you have to do to complete this particular task, further taking to our organs to adopt. It's also a huge task that we have to do in terms of completing the implementation of all human rights, especially with the current challenges outlined regarding resources and enforcement. Altogether, I'm happy that we agree that this session has been an eye-opener on the application and enforcement of human rights. We've also made a huge, huge leap in terms of including a guideline on youth participation. I think we must give ourselves a round of applause. Further, the inclusion of the Youth Charter will make a huge improvement to our document. It will strengthen and consolidate meaningful partnerships with the youth and parliaments. Parliaments have youth parliaments. Parliaments invite youth to their caucuses. Parliaments understand the language of a vote by a youth, and therefore It was quite progressive of you to consider youth and include them in this regard. Let me finally thank you, Landi. I cannot stop saying thank you to you. You have been an exceptional facilitator. You've been an exceptional resource, and you have been able to provide a balanced view that may further inform policy making at the national level. We have learned from you, and it is hoped that the technical working group will be able to own and convey the value of such a knowledge tool and the principles and guidelines through the various organizations at national level I've indicated. With these few words, colleagues, I thank you for your participation. I look forward to more engagement tomorrow. We may adjourn and have a good rest. Thank you.
So colleagues, you are on your own. Tomorrow, let's try and be, want to negotiate to start at 8 instead of 9. We are having a slight challenge with the consultant. He has taken up a new role where they keep timesheets. So we have tried to negotiate if we can do 8 to 9 with him. And then after that, we'll see how we can try and bridge the gap we face in terms of dealing with the tool in the consultant's absence. We attempted to do it with the technical, with the pre-testing. It worked with its own limitations. Let's see how it works out tomorrow. So we request that you rest early so that you are able to be here at 8, so that we are able to have him for an hour or so before he goes. There are a few things that emanated from the pre-testing that we all agreed that I think we really needed to hear from him in terms of what was in his head when those ideas were put as part of the tool. Do I get the consensus of the House? Thank you very much for your kind consideration. Otherwise, good night. The meeting had already been adjourned. Asante sana.